my lord, I'll be praying for recasting of the panel of OBC, my lord, which will be having, my lord, some repercussions. But it is, my lord, straight that in view of the fact that the OBC certificates, which were OBC B certificates, now his stands cancelled, my lord, the entire thing has to be recast. If your lordship kindly allows me, my lord, sometime, my lord, I can substantiate, my lord. It is very only this thing will be involved that in view of the judgment passed by the Honorable Division Bench, presided over by the Honorable Justice Tavabroto Chakraborty, the entire panel now has to be recasted. But this is a SLST matter. I'll be praying for it.
Mr. Lairi, have you filed any application?
Yes, my lord. The writ petition is pending, and the question arises with regard to this aspect only. The writ petitioner before lordship is an OBC category candidate who had secured the marks, but has not been given the appointment in view of the fact that it was being alleged by the commission that since there has been a process
now,
of...
Mr. Lairi, have you taken out any application on the ground of the subsequent event? Unless you bring those facts on record,
it is only a judgment. It is only a judgment that I'll be relying upon, my lord. That is the only thing.
No, then in view of that, you want the entire panel to be recasted. So because the other side,
if my lord, the other side has been put on notice, my lord, this is a candidate, my lord. If your lordship is of the view that only in respect of this candidate something has to be done, then that can also be my prayer, my lord.
So that cannot be, Mr. Lairi, that cannot be done with regard to a particular candidate, because it will have huge ramifications, because it's not that only for one person it is to be recasted. If recasting has to be made, it has to be of the entire panel.
Yes, it has to be. In any case, one person is before your lordship who is, my lord, agitating these points. If the recasting is done, she will also get benefited. That is the point. That is the adversarial litigation that is there before lordship. I'll be praying for inclusion, and my lord, if your lordship kindly takes it out.
No, Mr. Lairi, similar matters are pending before the principal bench also.
My lord, I am not aware, but my lord, in before your lordship,
Mr. Lairi, please inquire. Otherwise, there will be conflict of decisions, because this is a matter which will have to be.
There has been no decision. My lord, kindly, my lord, there has been no decision on this point. The day before yesterday, the government of West Bengal has withdrawn the SLP. It is only on last week, Friday.
Mr. Lairi, the government has, the state has withdrawn the SLP, but few SLPs are still pending. At the instance of private parties, those are still pending.
3 to 4 SLPs which were pending, all have been withdrawn. I have the order, my lord. I can
No. Please check up, because in other capacity, I have a definite information with regard to that. There are several others.
Well, kindly include, my lord.
At the instance of the private party, please take info. Please inquire, because there are.
I will inquire.
To my knowledge, there are few other SLPs which has not been withdrawn. That's pending.
I will inquire.
That knowledge I have in a different capacity. I have
as
that
of
knowledge.
Now, I'm be praying for inclusion, my lord. Kindly include the matter, my lord, so that, my lord, if the other side comes and shows all these things, I will be also making out the case to that effect that by an administrative orders, the previous notifications, but on the basis of which I was being denied, has been withdrawn. So therefore, as of today, the candidate before lordship who had participated as OBC A or OBC B has to be all treated as OBC, and thereafter the recruitment process can go on.
Yes, please hand over the slip. Yes.
My lord, my junior is there, Ms. Chianobis, my lord.
Yes.
My lord, I have already handed over the slip, mentioning slip. Can it be fixed on 24th?
No. Please give the slip. I will consider that.
Okay, lordship, there are 3 motion matters.
Motions, please hand over the slip.
Your lordship, may I be permitted to mention one matter for inclusion? This is a motion matter, your lordship. It was mentioned yesterday regarding cross FIR. Your lordship has been kind enough to allow the mentioning, but it has not appeared.
Slips have come.
My lord,
one to that. If you have mentioned yesterday, you did not mention.
My lord, one matter, my lord, the petitioner is the BSF employee. His, my lord, APR, my lord, has been downgraded, my lord, without communication to him, which is not permissible in the eye of law. My lord,
matter.
My lord, for which, my lord, his promotion has been affected. Lordship, lordship, kindly take it up if your lordship's
Lordship,
subject to your lordship.
I can proceed.
Yes, I am handing over the slip.
Lordship, may I be permitted to mention?
Yes.
Lordship, it's a writ matter filed against State of West Bengal, WBSCTCL. There were several orders passed by the Honorable Court to file a report. But
What do you want?
the state isn't filing a report. That is why matter is pending. So there
Have you
were
served upon the government pleader?
yes, my lord. Yes.
When have you served?
Today.
Today?
Yes.
The copy of the writ petition.
No, the matter
Because
is
the panel has changed now.
yes. Already earlier also notice served, but the matter.
After change of panel, have you served the copy of the writ
Yes,
petition?
I have served it in their office. Just right. I know.
Copy of the writ petition you have served.
No, not read petition, my lord.
Sir,
Read petition
how-
is record is already there. It's there already. The record is already there.
Yes, records, the erstwhile honorary advocates have returned the briefs.
Not all have been written.
At least this matter confirmed. The office confirmed.
Confirmed.
Yes.
All right, hand over the slip.
My lord, may I be permitted to mention one matter?
What is the application for? Expeditious hearing of what? Then expeditious hearing application is no use, so matter has to be hard. Please, I have no difficulty in taking up hearing matters. Then I can take up hearing matters. Motions, please don't mention for motions there. I have no difficulty personally for taking up hearing matters. I am telling you, I can take up hearing matters. If the bar wants the hearing is to be given precedence, for me, I have no difficulty. I can keep hearing matters, but the motions will not be taken up.
Lordship, at least be listed.
Let me see how far I can proceed with
My
the
lord, in
motions.
this-
Thereafter, I will consider.
In this matter, my lord, I am the petitioner in person, my lord, and this particular petition was filed for in 2023 pertains to the violation of my fundamental rights, and two petition more which are analogously heard were filed by persons who are similarly footed, my lord. My lord, this petition, all the pleadings are complete. I know this is a hearing matter, my lord. But there is a order and everything written there. Whoever honorable justices attended the matter, my lord. Everywhere it is shown that there is a point of difficulty which we are facing also while we practice, my lord. We have sufficient proof of that. I don't want to agitate that. The only point is this provision which was inserted by way of an amendment in the Constitution of the Bar Association of Siliguri, my lord. It violates the fundamental right and act against the Constitution also, against 19(1)(c) of the Constitution. It writes that if you're a member of another bar,
All right, hand over the slip.
as you
Lordship, may I permit to mention two matters, Lordship. There was a direction to file opposition, Lordship. Till date, no opposition has been filed, Lordship.
Hand over the slip.
My lord, may I be permitted to mention?
This part of. My lord, this.
Yes.
My lord, may I be permitted to
Yes.
mention item 150 and 151 of my lord's list? My lord, in this matter,
Yes.
in terms of the agreement, the respondent authorities are not giving me long-term lease. As such, the bank is not giving me any loan. My lord, this is a very short matter. My lord, kindly take it up on any day, my lord. The petitioner company is suffering for a very long period, my lord.
All right. 150 and 151.
My lord, may
Yes, my lord, 150 and 151.
my lord,
All
may I
right,
be permitted
please.
to mention one matter, my
My
lord?
lord, this matter was.
My lord,
My
may I
lord,
be
this matter
permitted
is
to
still in the
mention one
motion
matter, my
head.
lord?
My lord, this matter was conducted by my learned senior as Muralidhar.
Yes.
My lord, this matter is again fixed for 30th July after exchange of affidavits. My lords, I'm requesting this to be kept on 29 July instead of 30th July because he's already has a fixed matter in the Supreme Court.
Hand over the slip. Yes. Yes,
My
Mr.
lord,
Chakraborty.
my lord,
Permitted to mention one matter, my lord?
this will make fixed on 29
Let
July.
me see. I will consider that. Date fixing,
lord-
I will consider. Yes.
My lord, may I be permitted?
Yes,
to
Mr.
mention one
Chakraborty.
matter, my lord? My lord, this is my lord
Yes.
for inclusion in the list, my lord, in the last circuit bench, my lord, the matter was taken up for hearing. And their lord, my lord, directed to matter to appear, my lord, before this bench, my lord.
All right, hand over the slip. Yes, call the list.
one matter for
My lord,
one mention.
Yes.
One matter for non-prosecution.
Non-prosecution. Hand over the slip.
My lord, direction for affidavits by the state, my lord, the state is on notice, was passed in the month of June.
Yes.
I'm just praying for the further direction on the state, my lord, because the affidavits have not yet been.
Further direction is not necessary. Yes.
My lord, kindly.
Call the list. Call the list. আসুন। It has been pointed out that WPA number 10652 of 2020, which stood disposed of by an order dated 4th of January 2021. No, it doesn't. No, which category stood dismissed, stood disposed of before the principal bench. First up. However, the records have been transmitted to the circuit bench at Jalpaiguri, and the writ petition has been subsequently renumbered as WPA 769 of 2026. First up, since the writ petition already stood disposed of before the principal bench, by an order passed by the principal bench, no further order is necessary. Full stop. It is recorded that the writ petition already stood disposed of. Full stop. The learned register circuit bench is requested to ensure that this writ petition is not shown as pending in the docket of the circuit bench any further. Yes, next.
Order number 2.
Done. Ashu. Principal bench petition number WPA number 10646 of 2020 stood disposed of by an order dated 4th of January 2021. Circuit bench number 771 of 2026. Same order. Next.
Order number 3.
Ashu. Principal bench number is WPA number 10641 of 2020 stood disposed of on 4th of January 2020. Circuit bench number WPA 77 of 2026. What are the WPA 6113 of 2021 Principal Bench. Order dated 22nd March 2021. এখানে number হচ্ছে 773 of 2026. Next.
Number 5.
WP 820 within bracket W of 2019. Within bracket W of 2019. ঠিক আছে? এটা এখানে নাম্বার এটা disposed of on 22/1/2019. 22/1/19 আর এখানে হচ্ছে WPA 774 of 2026.
Just in case you say.
Yes, next.
Item number 6.
I'm for the petition.
I'm the statement.
Yes.
Matters pertains to police in action.
Police in action.
Yes, ma'am. The case is that on 5/6/2026 at about 9 AM, my lord, the FIR named accused person, there are 15 accused person come to the house of the petitioner and my lord vandalize his entire house along with his motorcycle. Thereafter, my lord, they have been assaulted the 70 years old mother-in-law of the petitioner who, my lord, sustained a head injury. My lord, kindly see page number 45.
Yes, what do you want now?
Yes, ma'am. Thereafter, my lord, I lodged the complaint before the police authority. My lord, police registered the FIR, but my lord, police registered the FIR in such a manner, my lord, so the accused person get benefited from this. What happened, my lord? There is an allegation of
What can be done in a writ
my lord,
petition?
kindly see.
My lord, case
Allegation-
counter case is there, my lord.
My lord.
One person arrested.
There is a specific allegation of
What do you want from the writ court now?
my lord, to direct the superintendent of police to my lord conclude the investigation, my lord, under his guidance within a specific period of time. What happened, my lord? The case of section attempt to murder, but police have been registered the case under section.
For that, you have to move before the jurisdictional court.
But my
There
lord,
you can get the relief.
but my lord, police registered the case in such a manner, my lord, so the
Can
entire,
you not approach the jurisdictional magistrate for that?
my lord, I have also lodged a complaint before the superintendent of police. Kindly comes to page
No, I'm
number
asking you,
61.
can you not approach the jurisdictional
My
magistrate for
lord, I
such?
have, we can approach, but my lord, there is,
Then
because my lord, the allegation
there
is
is a
against the
specific
police.
remedy for that.
Yes, my lord, but
Why
my,
are you not approaching that remedy?
but my lord, my allegation is specifically against the police. Because my lord, police registered the case
So
in
the-
such a manner.
That is what I am asking you. Can the magistrate not pass any directions about the police authorities?
Yes, my lord,
Yes, my
there,
lord.
there can, but I have, there is a no bar, if your lordship kindly.
Then what is the no bar? You
My
can
lord,
give an effective remedy there.
But my lord, if I, it is until the, my lord, the charge sheet have submitted. it
In a
is
writ
upon the
petition,
police.
it can be directed that this section is to be added, that section is
No,
to be
no.
deleted. Then
That is my allegation, my lord, kindly directed the superintendent of police, my lord, to conclude the investigation under
yes,
his guidance.
what
My
is the
lord,
stage of
this-
investigation?
My lord, this is the land dispute case, my lord, regarding the one guard wall encroaching between the two family neighbors, lordship. But regarding the case, case and counter case has been initiated against both parties. And one person in this case, one person has been arrested and and IO collected the injury report. One is, two is injury is simple, one is grievous, my lord. I will seize the offending article also. One of the accused person, namely Gopal Sardar, arrested on 17/7, and I would recording available statement and read it several times, but the accused person have plead evaluation. This is the report.
My lord, the one person have been arrested after filing this writ application. What police have been done, my lord, police registered the case, so my lord, the punishment would be under the below 7 years. So the, my lord,
Investigation is
police
much
can-
more
police can
progress, my
submit
lord.
and Police can issue a notice to the.
Investigation much progress, my lord.
So my lord, police can issue a notice to the accused person under section 35(3) of the BNSS. So, my lord, they can comply and, my lord, take the bail from the learned trial court. What happened, my lord? Kindly see, police have been, my lord, give them notice under section 41A, that is the 35(3) of the BNSS. And, my lord, the accused person have been complied. And, my lord, thereafter, to show the progress of the investigation, my lord, police have been arrested one of the accused person after compliance of the 35(3) notice. And also, for my last instruction, my lord, the anticipated bail has been also been rejected by the London Session Judge.
What is your prayer here?
My lord, to send a special investigation team. But if your lordship direct the SP, I have a faith in SP. If he conduct the investigation under his guidance, my lord, that would be sufficient.
The report of the Sub-Inspector of Police, Kotwali Police Station, dated 18th of July, 2026, is taken on record. Full stop. From the said report, it appears that investigation in connection with Kotwali PS case number 277/26 dated 5/6/26 under section 126 within bracket 2/118 within bracket 2/109/74/351 within bracket 2/3 within bracket 5 BNS and Kotwali Police Station case number 280/26 dated 7/6/2026 under sections 110/118 within bracket 1/3 within bracket 5/329 within bracket 3 BNS is going on. Full stop. Paragraph list this matter on list this matter on July 28, 2026. Full stop. On that date, the SI Kotwali Police Station shall file a report in the form of an affidavit indicating the further progress of investigation in the aforesaid two cases.
Extremely good.
Yes, next.
I am on behalf of the petitioner, my lord. My lord, I have served on the respondents, my lord, but my affidavit is not ready, my lord. I can submit in the course of the day.
Yes, what is this?
My lord, this is a case against the Siliguri Municipal Corporation, my lord.
Against Siliguri Municipal Corporation? Who is appearing for Siliguri? You are appearing?
I am for the state, lordship.
State?
Yes, my lord.
Yes.
My lord, the case
So
in hand-
answering respondent is Siliguri Municipal
Yes,
Corporation?
yes, my lord. Yes, my lord. My lord, the case is that
Yes, Mr. Dhar, what have you done?
I've done nothing. False and furious
You have
allegations.
not done anything?
No, false and furious allegations.
Yes.
my lord, a huge quantity of garbage is being thrown in front of the house of the present petitioner, my lord. This started in the year 2023, my lord, and again in the year 2024. Two applications were filed before the SMC, my lord, and thereafter they did not dispose the garbage in front of the house of the petitioner. Thereafter, what happened, my lord? In the year 2024, again the same garbages was thrown. This time in the personal land of the petitioner. Again, he wrote to the SMC. Again, they stopped. Thereafter, in the year 2025, my lord, they were trying to construct on some construction on the roadside, my lord. Thereafter, he wrote a representation to the SMC and also brought into the notice of the SMC that there was an earlier writ file where there was a status quo order with regard to such construction, my lord. And thereafter, the SMC stopped. They did not do anything. But thereafter, from November 2025, they have been constantly throwing huge garbage, huge, in front of the house and on the road of the present petitioner, my lord. I have annexed the photographs of the same, which start from page number 84, my lord. Huge garbage. And because of that, my lord, twice, even a fire caught in the said garbage, and even the fire department had to be called to douse the fire of the said garbage, my lord. And in that regard, even on 8th May 2026.
Yes, Mr. Dhar. Whose responsibility is this to remove, clear this garbage?
This area is a.
Please use the microphone.
This area is a earmarked VAT. It has been used for the last 30 years. The VAT is on the municipal road. The entire garbage of the entire ward. It's a mostly businesses are taking place, so there is no other. That particular area was earmarked, and the garbage is collected from the
This
entire.
area has been earmarked.
Yes, it's being used for the last more than 20-25 years. Now,
Please kindly come to page 84. Whose
Yes.
signboard is this?
Yes, father. এখানে আবর্জনা ফেলা যাবে না।
yes,
They themselves-
I'm coming to that.
So in the
No, I'm coming to that. The bins are kept, big bins are kept. The garbages are thrown on the bins, and every day at
is it thrown on the bins?
these are
From the photographs.
I can file a report, Your Lordship. This is there.
No, I'm asking you, are you denying these photographs?
These photographs have been out there. Can you take the next page, Lordship? Can you take the next page?
If this is a garbage ground, then why have you fixed this signboard?
Bins are there. Bins are there.
No bins are inside.
Let me explain. Lordship. The bins are there. The garbages are dropped in the bin, and every day between 12 to 12:30, the bins are cleared regular basis.
No bins are found here.
I shall file a report,
not?
Lordship. I will annex the photographs of the bins, and I shall file a
Why not?
I'm
report.
appointing you as a special officer. Please go there and
I will
take a
also.
photograph
And
My
it is
and come back at 2 p.m.
I'm showing the.
and Lordship, this is
2
not a
p.m. I'm
case.
appointing you as a special officer.
And-
Please you go there,
and
please take a photograph
Lordship,
as an officer of the court and come back.
Lordship, may I?
Photographs of the bins
Please.
and what is the present position.
Lordship. I
2
shall,
p.m.
My
not 2 p.m. Can you give it to
Why?
today?
Today is the best day.
Then don't appoint me as a special officer.
Best. They are not objecting. I have trust in you.
My lord, after
No,
filing,
I have other matters also. Lordship.
Why?
I have other matters also, Lordship. I cannot go.
my lord, after filing of this writ, they have placed a bin, my lord. This is the
Why?
photograph of the same, my lord.
The beans are already there.
No,
Lordship.
there are no bins. So that's the condition of the bin, my lord. That is the condition of the bin at the present moment.
Ashun. The petitioner,
My lord, as per law, my lord, they cannot place even the bin over there, my lord.
That's
They
the
have
way-
to place the bin in an isolated place, my lord. They cannot keep the bin in a populated area, my lord, beside the road, my lord. They are
Let us-
violating
let us
the
alleges.
SOPs.
Come back with the
They are,
report,
they are,
Lordship.
they are.
that the Shiliguri Municipal Corporation is not performing its statutory obligation
My lord.
in removing the garbage which has been stacked on the road in front of the property of the petitioner. First up, Mr. Dawal, honored advocate appearing for the Shiliguri Municipal Corporation, denies the allegation made in this writ petition. First up, he submits that one bin or more bins,
My oral instruction are there are 2 bins.
the 2 bins have been kept on the roadside, on the side of the road for the purpose of dumping of garbages. And every day, between
12 to 12:30.
12 to 12:30
Yes.
p.m., the garbages
12 noon to 12:30 p.m. Yes.
between
Garbage,
12
the
to
bins are
12:30 p.m.,
The
the entire garbages are cleared on daily basis.
daily basis.
First up, Mr. Dhar further submits that the area where the garbages are thrown is for the purpose, has been earmarked
Yes.
for such purpose. First up, attention of Mr. Dhar is drawn to the photograph at page 84 of the writ petition, where from it appears that there is a signboard of Siliguri Municipal Corporation stating that garbages should not be thrown on that land. Full stop.
Yes.
No, it's not on that land, Lordship.
On
The
that
land of the.
এখানে
petition is
আবর্জনা
somewhere-
ফেলবেন না।
No.
Yes, not on the
And
land.
these are land photographs are shown.
No, this is the road. Beside the road, there is a hydrant. Thereafter,
Ah.
this is the land of the petitioner.
I'm not on the land of the petitioner. Please see the photographs.
Yes, this is on
So
the.
just in front of your
House.
signboard, what is the demarcation area you have to indicate?
We shall set it now.
Mr. Dhar seeks an accommodation to revert back with necessary instructions. List this matter tomorrow under the heading for orders to enable Mr. Dhar to revert back with necessary instructions.
I'm grateful, madam.
Lordship, instead of tomorrow, day after tomorrow, Lordship.
Why?
Better instructions.
No. Let me see what instructions
Lordship.
you are provided with. So from 2 p.m. today, I have kept it tomorrow.
I'm grateful, madam. I'm grateful.
Yes.
Item number 8.
Not possible, my lord.
Yes, Mr. Dhar, you have given this. No.
Hey, tell me.
Who has given? Yes, Mr. Sarkar, it's your. You have given this
Yes,
photograph.
yes,
Please take it
yes.
back. Yes.
Single short password, my lord. He's already.
Why short password? Please start. Yes, what is this?
Short password, my lord.
All right, pass over next.
Grateful.
Item number 9.
I don't know what name, Mr. Dipanjan Das is Lordship is leading me. He's on the virtual mode, Lordship.
May it please your lordship.
Dipanjan Das.
Yes.
My lord, very short point, my lord, kindly takes page 30 and 31 only. My lord, I am a BSF personnel, my lord. My lord, I had in 2010, my lord, stopped joining for certain period. My lord, thereafter, my lord, I was removed from service. My lord, upon prayers being made, I was reinstated in service with effect from 17th February 2011. My lord, now my lord kindly takes page 30 and 31 once. 30.
Yes.
My lord, page 30,
Yes.
the first line says that I was dismissed from service with such and such days. My lord, the overstay leave, OSL means overstay leave, was with effect from this period to this, my lord, of September 2010 to February 2011. This 148 days. But I have no dispute on that. My lord, now comes, my lord, my prayer. My prayer is only with regard to from February 2011. My lord, I was reinstated in service in, my lord, November 2011. My lord, this period they took, the BSF authorities took the time to get me reinstated. My lord, with effect from November 2011, I am still in service. My lord, I am only praying that for these 270 days, that is from February 2011 till November 2011, I was granted extraordinary leave. My lord, I have nothing with regard to any enhancement of salary, or only my prayer is that period be considered for increment in my entire service. That is my only prayer. They have rejected my prayer completely on a different notion. Page 31 is their reasons. The period of OSL, that is the 148 days where I was absent, shall be regularized by committing it to EOL under Fundamental Regulation 85B. Fundamental Regulation says that with regard to extraordinary leave, they can take a decision. I have nothing to say with regard to that 148 days. They now say that they are ready to regularize it. That is even more beneficial to me. But for the period of 270 days, which is subsequent to my dismissal, where they took time for arriving at a decision. that is the period where there was no latches on my part, because they admit that 148 days was my absence. But subsequently, it was absolutely their decision taking time. Ultimately, in November, they ultimately arrive at a decision of reinstating me. Immediately, they give me the opportunity. I rejoined. I have been working since then. The only period which I seek benefit for increment, nothing more, is with regard to that 270 days where they say that they are agreeable or they are regularizing my OSL, that is the prior period. But I am not asking for the prior period, because there I was admittedly absent. I have nothing more to say with regard to the prior period, because I cannot get benefit of the period where I was absent. But for the period when they say that I had asked for their beneficiary benevolence, they extended me the benevolence, they reinstated me. I am only praying that this period be given effect with regard to my increment for the entire service.
Yes, what do you say?
Lordship, the writ petitioners unauthorized absence in earlier also. There is 23rd September 2010, Your Lordship, 1 day earned leave. 24 September to 19th October 2010, 26 days half pay leave. 20 October 2010 to 17 February, 121 days extraordinary leave. And Your Lordship, subsequently, when say dismissed and reinstated, that is 270 days extraordinary leave. For the increment purpose and for that year, the writ petition is not qualifying yet.
According to Mr. Dotto, that there was delay on your part to reinstate him. So can he be faulted for that?
Lordship, the order 18 February 2011, Your Lordship, said dismissed from service. And after
Where are those orders? Where are those orders?
Lordship, in this writ petition is not annexed. If Your Lordships permit us, then I'll file all the orders, Your Lordships.
Yeah.
That is required.
But I allow you to file a report within a short time.
Yes,
We will
Mr.
annex all-
Dotto, let a report be filed. Otherwise, let them.
We'll annex all the
My
documents.
lord,
and file
that
it.
can be one way of looking at it. My lord, I can also suggest, subject to my learned senior friends of the other side considering, my lord, this apparently the decision or the justification which they give is with regard to the period where I was admittedly absent. I am not seeking any benefit therefrom. My lord directs them to consider this part and take a written decision with regard to the period I was actually not at fault. And they give me a reasoned decision with regard to that period only. That could have sufficed the purpose, if my lord so desires.
Well, we will get the order from Jammu, the dismissal order that was passed in the J&K. We'll bring it all, we'll disclose all before the honorable court, and the court will decide. If he gets, he will get. If he doesn't, he doesn't.
When can you file the report?
My lord, kindly fix it, gives that, let us take a chance in the next week.
Next week?
If we can bring it from Jammu, well.
Otherwise, time.
Let a report be filed. Who shall file?
138 battalion. Respondent.
Commandant.
Commandant
Respondent number
138 battalion.
Commandant
Let a
138.
report be filed by the Commandant 138 Battalion Border Security Force, being the fourth respondent, with regard to the issues raised in this writ petition, on or before the next date of hearing. List this matter on July 29, 20. Can you come on 28th of July?
Lordships. 29 or 30.
29th of July 2026, under the heading motion.
Much obliged.
Yes, next.
যাবো এখন।
Not I am for the petition. Not hearing the individual of seconds. My lord, in this matter, the petitioner is a 59 years old person who since last 26 years running his livelihood by my lord a tea stall. What happened, my lord, on the day of election, my lord, some miscreants came to his tea stall and my lord asked about whereabouts about his son, my lord, who is an active member of an opposition political party. My lord, when the petitioner denied about knowing about whereabouts, my lord, at that time all the miscreants, my lord, at first vandalized his shop, only a tea stall, and my lord, thereafter my lord dragged out of from his tea stall, and my lord put padlock in the said tea stall and asked him not to dare to open the said tea stall without their permission. My lord, since case of 4/5/2026 till date, my lord, the only a tea stall has been stopped by them. My lord, kindly comes to page number 33. Yes. My lord, that is the photograph of the tea stall. Kindly see the vandalization. And thereafter, my lord, I lodged a complaint before the police authority. My lord, till date, my lord, not the complaint. My lord, my only submission, humble submission before the police authority, my lord, to give me the protection. So, my lord, I can open my tea stall. My lord, till date, they did not give the protection.
Yes, what is the instruction?
Stall will not is situated in a road.
Yes.
Illegal construction will not, no permission was taken from the municipality, nothing, the instruction will finally come.
My lord, since last 26 years, my lord, I am operating the tea stall. My lord, neither the PWD have been ever complete.
On a road will not public road.
Neither the PWD nor any. Now, my lord, the police, my lord, taking the plea that it's the unauthorized construction. My lord, if my tea stall is unauthorized, my lord, the entire bazaar will be the unauthorized construction.
So who is the owner of the tea stall?
Mintu Gohara, that is the present petitioner.
Yes, but what is your report in paragraph 9?
Paragraph 9 stated.
On Peruzal, it has come into the light that the owner of the tea stall, Mintu Gohara, has not given any permission to open a tea stall at. Who will give permission to?
Municipality. Municipality, the municipality or the Gram Panchayat. This is the public road, Miller. They encroach the Rasta. They have stall, in their report having.
Not kindly see the photograph.
There is no other encroachment on that road.
Kindly see my photograph.
The report.
No, I'm asking you. An inquiry was made. Can you submit the report of the inquiry? Whether it was restricted to only one shop room or the entire area?
But that steps I have to take.
Please take instructions. Please produce the entire inquiry report of that locality. Because it must be not only with regard to one stall. Since you are trying to remove the encroachment, it has to be.
I have not.
So this report says that so inquiry, if it was made, has not to be directed with regard to one person only. So you want to remove all the encroachments in that area. Please show me the report of the inquiry showing all the encroachments over the public drain. Ashwin, the petitioner alleges that in spite of a specific complaint lodged with the police authorities, no effective steps have been taken by the police authorities till date. Full stop. The learned advocate representing the state files a report of the inspector in charge, Mathabaga Police Station, dated 21/7/2026, which is taken on record. Full stop. Upon perusal of the said report, this court finds that a prayer was made before the Block Land and Land Reforms Officer, Mathabanga 1 Block, for providing the land identification and status of land. Full stop. Where is the report of the Block Land and Land Reforms Officer? You have annexed this 20th of July.
What page, Milord?
From the memo dated 20th of July 2026, issued by the Revenue Inspector to the Block Land and Land Reforms Officer, this court finds that the suit land was recorded in favor of Works and Buildings Department. Full stop. The full stop. The state director, the respondent number any proceeding has been initiated for removal of encroachment?
The report only I have no further taken step.
On a query of the court as to whether any proceeding has been initiated for removal of unauthorized encroachment from the government land / land belonging to the Public Works within brackets Roads Department, the learned advocate appealing for the state seeks time to revert back with necessary instructions. Day after tomorrow, list this matter. Day after tomorrow, under the heading motion to enable the learned advocate to revert back with necessary instructions.
Yes. Affidavit of service we kept on. Affidavit of service.
Every service taken on record. Yes.
Order number 11.
My lord, it's a pension matter where the petitioner's son, led Vijay Chakraborty, has expired and in the year 2003, but still the pension has not been
Yes, who is appearing?
It's Union of India, but Union of India, the copy has not been served and it's still in the
Need some instruction matter.
process. So, and may the listed on the next week.
You were serving where?
He was serving on Bagdogra Departmental Canteen on Ministry of Defense. And during his tenure, he expired on 6th February 2003. And in the meantime, many representations was given by the petitioner as being the old age person of 71 years. No response has been given from the ends of the defense. And
Petitioner is the mother.
yes, mother of the deceased Vijay Chakraborty, who was employed in the departmental canteen.
Take a decision on this representation. Ashun. The petitioner claims that her son, Vijay Chakraborty, who was working in departmental canteen stores at Bagdogra under the Ministry of Defense, died intestate on 6th of February 2003. Sister. Petitioner, his wife is there.
Yes, his wife has been married to some other person, now residing separately, cutting all ties with the matrimonial
The
house.
petitioner, but in the representation,
Mother made the representation alone.
the petitioner alleges that the wife of Vijay Chakraborty has left the matrimonial home on her own will after the death of the petitioner's son, and she has remarried. First up, the petitioner submitted several representations before the respondent authorities, requesting the authorities to disburse the pension in her favor. First up, the learned advocate appearing for the petitioner submits that the last of such representation was dated 30th of April 2026 has submits that no decision has been communicated to the petitioner in spite of the fact that the petitioner has submitted several representations and the last of which was dated 30th of April 2026. First up, the learned advocate appearing for the respondent submits that the decision on such representation shall be communicated to the petitioner within the time limit as may be fixed by this court. Respondent number 2, area manager.
Yes.
The without entering into the merits of the claim made by the petitioner in the representation dated 30th of April 2026, WPI number such and such as disposed of by directing the area manager, department, canteen stores, Government of India, Ministry of Defense, Bagdogra, being the second respondent, to consider the representation of the petitioner dated 30th of April 2026 and dispose of the same by passing a reasoned order after affording an opportunity of hearing to the petitioner, and any other person who may be affected by such decision, including the any other person who may be affected by such decision and communicate the reasoned order to the respective parties as expeditiously as possible, but positively within a period of 6 weeks from the receipt of a server copy of this order, together with a copy of the representation dated 30th of April 2026. Next.
Order number 12.
Well, my lord, I appear for the okay.
I'm for the petition, my lord.
My lord, before my learned turn starts, my lord, can I come back day after? I'll tell you lordship why, my lord. We
Right.
have received instructions, but there was an earlier order of the Honorable Coordinate Bench, which is at page, my lord,
45, 46.
46. Now, the writ petitioners are, my lord, alleging non-compliance of that order. As per my instructions, my lord, that a decision on that representation has been taken. But what the instruction lacks is that whether it was communicated to them or not. If it was not communicated, I'll hand it over to the writ petitioner day after. Just one day accommodation. Grateful.
The petitioner, every service filed in court today is taken on record. To stop, the petitioner alleges that in spite of a specific direction passed by a coordinate bench in the order dated 20th of April 2026 in WPA 613 of 2026. No decision on the representation dated 28th of March 2025 has been communicated to the petitioner till date. To stop, Mr. Bhattacharjee, on an additional government pleader submits that the decision has already been taken
By the headmaster of the school.
by the headmaster of the school. In the meantime, full stop, he prays for an accommodation to place the decision, to place such decision before this court on the next date. On the prayer of the learned advocate, learned additional government pleader, list this matter day after tomorrow, 30th. No, sorry, 23rd.
23rd.
Yes. Next.
Grateful, my lord.
Order number 13.
Under the heading for orders.
And for the petitioner, who is the headmaster of the school.
Petitioner is the headmaster, yes.
Yes. And kindly.
3%. 3% increment.
3% increment. Yes.
Kindly see page number 33. Last page, that is the.
Claim has been rejected.
Yes, yes.
Here it has been rejected.
And page number 30. Salva copy of coordinate bench. The notification which was
Memo.
based.
So this has been set aside.
And that has been set aside. And they have relied on that.
Which paragraph this has been set aside? Please show me.
21 to 30. No.
No, this memo dated 22nd of March 2017 has been set aside. Which paragraph?
Last selection. Paragraph 9. Paragraph 8.
Paragraph 9.
9. Last 9. Annexure. That is the order of the DI.
No, this is of the coordinate bench decision you are saying.
No. 10. Paragraph number 10. That is the order passed by DI.
Page.
Page 6 of the application.
6 of the writ petition. No. This rejected, but I think this memo has been set aside by the coordinate bench. This 22nd of March 2017.
That is in paragraph number 8, Lordship, the order passed by this coordinate of the honorable.
Relied on a notification dated. No. Where is that? I think in yesterday's,
21 to 30.
in view of this court directs the setting aside of the notification dated 22nd of March. Yes, so quadrant bench has set aside this notification. So I'm recording that, I'm setting aside this and directing you to take a decision on that. Ashwin. The petitioner claims to have joined the institution.
May I add one thing, Lord? Kindly to the instruction.
What is this?
For a no additional increment 3% is only paragraph number 2. Although it was set aside.
Yes, so this has been set aside by the coordinate bench.
Wait. This is Lord.
Kyola? As an headmaster, on 10th of May 2006, first up, the said institution was upgraded as a higher secondary school by virtue of office memo dated 8th of October 2013. Full stop. Petitioner submitted application before the concerned respondent authority praying for grant of additional increment at the rate of 3% in terms of the memorandum dated 22nd of March 2017. In terms of the memorandum dated
22nd March 2017.
22nd of March 2017. Full stop. The prayer of the petitioner for additional increment at the rate of 3% has been rejected by the District Inspector of Schools within bracket SE, Jalpaiguri, dated 7th of November 2025. First up. Being aggrieved, the petitioner has approached this court. First up. The learned advocate appearing for the petitioner submits that the prayer of the petitioner for grant of additional increment at the rate of 3% was rejected by applying the provisions contained in memo number 292-SL capital dated 22/3/2017 issued by the Secretary to the Government of West Bengal. Full stop. He submits that the said memo has already been quashed by a coordinate bench in the case of Kachiram Sarkar and others versus State of West Bengal and others. Has been quashed by the coordinate bench by an order dated 7th of May 2024, passed in WPA 23867 of 2017 in the case of Kachiram Sarkar and others versus the State of West Bengal and others. Full stop, paragraph. The report of the District Inspector of Schools within bracket AC dated 17th of July 2026, filed by the learned advocate for the state, is taken on record. Full stop. In the said report, it has been stated that the petitioner that no additional increment can be allowed in favor of the petitioner in view of the office memo dated 22/3/2017, since the school was upgraded after upgraded as a higher secondary school after 27/2/2009. Just a paragraph. The issue as to whether the headmasters are entitled to additional increment at the rate of 3% for the institution being upgraded at a higher secondary school on or after 27th of February 2009 fell for consideration before the coordinate bench in Kachiram Sarkar and others. First up, in paragraph 20 of the said decision, the coordinate bench was pleased to set aside the notification dated 22/3/2017. Full stop. In view thereof, this court holds that the respondent authorities could not have invoked in view thereof, record reveals that the prayer of the petitioner for grant of 3% additional increment was set aside, was rejected by the District Inspector of Schools within bracket AC Jalpaiguri by issuing a memo subsequent to the passing of the judgment in Kachiram Sarkar Supra. Full stop. For such reason, this court is inclined to for such reason, this court holds that the District Inspector of Schools AC could not have rejected the prayer of the petitioner by relying upon the memo dated 22/3/2017. Full stop. In view thereof, the decision of the District Inspector of Schools within bracket AC Jalpaiguri communicated to the petitioner via memo number 2364 dated 7/11/2025 stands set aside and quashed. Full stop. The District Inspector of Schools, the Commissioner of School Education, being the Commissioner of School Education being the third respondent, is directed to consider the representation of the petitioner dated 7th of October 2025 afresh in the light of the observations made herein before, and strictly in accordance with law, after affording an opportunity of hearing to the petitioner or his authorized representative and communicate the reasoned order, and communicate the reasoned order and dispose of the same by passing a reasoned order after affording an opportunity of hearing. Yes, and communicate the reasoned order to the petitioner as expeditiously as possible, but positively within a period of 4 weeks from the receipt of a server copy of this order. Full stop. He is still in service.
One thing, Milord, the 7/10/2025 letter it addressed to Joint Secretary. They held in the respondent number 2. That your lordship is directing to respondent number 3.
Yes, Commissioner of School Education is the appropriate authority. No, what is this representation?
Yes, sir. It is the Joint Secretary, Milord. Page number 31.
Commissioner of School Education, you have not made any representation.
Yes, your lordship.
Yes.
Joint Secretary, 2, respondent number 2, my lord.
अच्छा की बोलना तो together with a copy of the representation বলেছি তো এটাও লিখে দিন it is however made clear that though the representation has been addressed to the joint secretary this page where is that
31 page number 31.
Though the representation has been addressed to the Joint Secretary, School Education Department, Secondary Branch, representation dated 7/10/2025 has been addressed to the Joint Secretary, but the same shall be considered by the Commissioner of School without raising any technical. Yes. Next.
Under number 40, my lord, I am from the petitioner. My lord, the matter, my lord, pertains to my lord deletion in electoral rolls. And my lord,
Your Lordship, I appear for the Election Commission of India. My learned friend could provide the scanned copy and tomorrow matter could be taken up.
my lord, my only contention is that, my lord, to my lord, this direction may be passed the appellate tribunal. My lord, to dispose of the my lord,
Lordship,
appeals which are pending,
similar
my lord,
orders
as
have been
it's
passed
just-
by the coordinate bench. It can be
Similar
disposed
order,
of.
my lord,
I'm only, but the copy may be served first, Your Lordship, because I need to
Yes,
forward
yes,
it to the
please serve a
protocol
copy.
officer.
Yes, ma'am.
My lord, inputs of the day, my lord,
Copy may be
Madam, only Pandey, only one thing. What is the stage of the appeal proceedings before the tribunal?
Your Lordship, there are few tribunals who are disposing of 500 matters per day. There are few who are disposing of 10 to 20. So it is different. But matters have been taken up and disposed of. In terms of your Lordship order, kindly give the time only in medical condition and students immediately and rest within 4 months.
my lord, urgency is also there. my
No,
lord.
I could not follow this. What is your submission?
Your Lordship, the other coordinate bench has passed an order giving time for 3 to 4 months to dispose of the appeal by the requesting the tribunal to dispose of the. My junior is carrying one
Yes.
such order. She'll hand it over in all those matters, but I need the scanned copy to be handed over to the protocol officer for the SIR tribunal. Otherwise, they can't dispose it of. So
Yes,
these
yes,
matters where
please
they have not served.
My lord, today in course of the day, I can give the
Course
scan
of the
copy.
day, please give.
My lord, may I hand over? My lord, may I hand over a copy of my lord similar order, my lord, passed by the learned honorable coordinate bench, my lord.
হ্যাঁ আমাকে একটা কপি দাও
Your Lordship, our principal bench has made it for 4 months. Kindly pass such orders because it is numbers are increasing, so it is becoming difficult for the tribunal.
4 months, by which order it has been directed to be disposed of within 4 months? Well
Your
said.
Lordship, there are
So far,
several orders. Even last week, certain orders were passed. My junior can hand it over within the course of the day.
In the principal bench.
My lord,
Your Lordship, Your
Krishna Rao,
Lordship,
In the
Honorable-
Honorable Justice
Yes.
Krishna
Please,
Rao is
Lordship.
taking up matters.
Uh,
My lord, I am handing over the.
My lord, may I hand over one copy?
do you have an oh, chale gaya. Madam, do you have an idea as to this is within which jurisdiction?
This
Uh,
is falling under Jalpaiguri, Your Lordship.
Jalpaiguri. No, this is Kuch Bihar. Kuch Bihar is also within Jalpaiguri,
My lord, my lord.
or different
My lord.
appellate tribunals are there for Kuch Bihar.
Yeah, there are total 18 tribunals. I will hand it over to the appropriate tribunal which is taking up the matter. Your Lordship can dispose of by passing a one-page order.
All right.
My lord, one indulgence, my lord. My lord, if it is possible, my lord, the appeal number, that
appeal number
in connection with the epic number of the petitioner whose name has been deleted, that may be reflected in the order.
it's difficult. So, longish order, then it will be
Very
coming up.
convenient, my lord.
You
Only
will
the
be
epic
giving the
number-
copy. Your matter will be there. Epic numbers. It's difficult.
If, my lord, it is mentioned in the order.
Your Lordship,
only
it
the
is
there
not
is- if there
required.
is- If there is
Your Lordship, with the writ
one
petition, I'll do
mistake,
it.
typographical mistake, if this is a longish number, then the not be
sir.
carried out. You will be in difficulty.
My lord.
The petitioner has approached this court seeking a direction upon the special intensive revision appellate tribunal to dispose of the appeal filed by the petitioner within a specified time frame. Full stop. Ms. Pandey, learned advocate, appears for the Election Commission of India. Full stop. She submits that a large number of appeals are pending before the appellate tribunal, and the appeals are being disposed of by such appellate tribunals on day-to-day basis. Full stop paragraph. However, taking note of the fact that the appeal is pending for a considerable period of time, comma, WPA number such and such stands disposed of by requesting the appellate tribunal to take up the hearing of the appeal filed by the petitioner and make an endeavor to dispose of the same as expeditiously as possible, but preferably within a period of 3 months from the receipt of a server copy of this order, together with a photocopy of the what are you getting, an acknowledgement, or what are you getting
My lord,
when you
that-
file?
Yes, my lord, that is acknowledgement of appeal, my lord.
Together with the acknowledgement receipt indicating the appeal number and
Your
the date
Lordship,
of
may
file.
I, my apology for
Yes.
intervening. Your Lordship, the paperwork
Yes.
increases with the tribunal. It is getting difficult for them to handle. My learned friend provides a scanned copy. It shall be done. No other thing is required to be recorded. Just the appeal may be disposed of within 3 months. Because the tribunal is also facing allocating documents with the case number.
All right.
So-
Together, together with the acknowledgement receipt, কেটে দিন. From the date of communication of a server copy of this order. Full stop. Next, it is however made clear that this court has not entered into the merits of the claim made by the petitioner in the said appeal, and all points are left open to be decided by the appellate tribunal in accordance with law.
Your Lordship, similar order for item number 15, 17, 18, 19, and 20.
15,
17,
17, 18, 19, 20.
17, 19, 20.
17, 18, 19, 20.
18 also.
18
Yes,
also.
ma'am.
18 also, Miss Pande.
Your
18
Lordship,
also.
Your Lordship.
18
There are
also.
more than
There are, my lord,
30
three
matters, Your Lordship, today.
My lord, 23, 26, and 27 also pertains to my lord.
You are appearing.
Yes, my lord.
Miss Pande, you are appearing. 23.
I am appearing in all
Yes,
the matters,
madam.
all the matters, Your Lordship.
All the matters.
23, then
23, 26, and my lord, 27.
23, 26, 27.
Yes.
Your Lordship.
My lord.
Thereafter, from 61 it starts, Your
You are
Lordship may take
appearing
it
in
up.
24, 25,
24,
25,
25,
30.
30. Yes.
My lord, copy we have not
Yes,
received, my
please
lord.
give the
Yes, my lord,
copies.
import of the record.
Acha, at Likadin, the learned advocate for the petitioner, is directed to serve a copy of this writ petition.
Scan copy, my lord.
Scan copy of the writ petition to you.
Madhusri Datta.
Uh,
Madhusri Datta.
to the learned advocate on record representing the election commission before the circuit bench at Jalpaiguri.
Your
Yes, Ms.
Lordship,
Pandey.
Your Lordship, Madam is not impaneled with the election commission. She is my junior.
Then
They
to
may
whom it
serve
shall
it
be
to
sent?
me. It will be
All
sent
right,
to me, Your
Tale-
Lordship.
Acha,
Yes, ma'am.
is directed to please send it to our is directed to serve a scanned copy of the writ petition upon Miss Pandey, learned advocate, who is representing the election commission of India. তাহলে circuit bench fence কিছু লেখার দরকার নেই.
Grateful.
Yes,
Deeply obliged.
Grateful, my lord.
yes, call the next matter. Please give your appearances indicating the item numbers or the writ petition numbers, whatever it is. Yes, next, call the next matter.
Item number 16.
Yes.
Item number 16, I'm appearing for the petitioner.
Now you have switched side from that side to this side. Yes.
This is pertaining to intra-district transfer of the petitioner, Your Lordship, intra-district transfer on the ground of surplus teacher and distance. She is a mother of
Transfer on the ground of
distance and she is a surplus teacher where she is.
surplus teacher.
Yes, Your Lordship.
So I'm hearing for the first time.
Yes, Your Lordship, the PTS is.
I'm accustomed with hearing that of teachers. Surplus teacher is for the first time which I am hearing. Yes, yes, who is for the respondent?
Lordship, DPSC, I'm representing to the board.
Mr. Ghosh, you are representing board. So the board is to,
So this is intra-district, so the DPS.
Lordship, there is no impediment, but
what is this? No impediment, but this is the impediment.
this is the impediment. Can goes through the same? This is a notification by the government.
Your Lordship.
No, a temporarily suspended online portal, so it can be done physically.
No, Lordship, now the second paragraph. It was suspended, now it's open.
Your Lordship, then I would like to.
All right, I will clarify that if it is through online, she is able to log in.
That's the thing.
Or not, then physical mode.
Your Lordship, I would ask them to kindly demonstrate this because I have asked my client, I have specific instruction that it is under maintenance because only one school is showing for the district of Jalpaiguri, Your Lordship.
Division bench.
Yes, this is a division bench judgment.
Before your lordship.
Kindly places.
Copy card, order copy card.
Paragraph 6 of the judgment, Your Lordship. Page 2, paragraph 6, Your Lordship. Your Lordship, for the district of Jalpaiguri, as per my instruction, Your Lordship.
13th of July, you order division bench. It's under repairs.
So I have to seek instruction then.
No instructions, I am following this order. If the portal is rectified, he may respond. Written copies of the response also may be
But
communicated.
the only thing is that whether it is rectified or not, that has to be. Yeah.
If it is under repairs, not functional, that order was passed on 13th of July. Now today we are on 21st of July. So there may be teething problems now also. After repairing what has been done.
But yesterday, my instructions are that it's functioning. Yesterday.
It is functional.
Your lordship, kindly let them demonstrate in the court, your lordship. Because as per my instruction, only one school is there, that is Mehrun-Nisa, and the PTI is also not correct, your lordship. Let
So I
them
think
demonstrate.
you can help her.
Yes, your lordship, let them
logging.
demonstrate then.
Yes.
Let them
That
do
will be better because you will be knowing whether there is any problem or not.
I'm only backed by
Not
this.
only this,
instruction.
don't go only by the instructions. Because a lawyer is saying with
No,
instructions
no,
that this is under repairs, there's also division bench judgment. And you are not denying that.
No, I'm not denying. Only thing is that they are saying the DPSC is saying it's functional. So I have to
ask the DPSC persons to come
Lordship.
to demonstrate to you
Lordship.
In our presence.
That will be better.
Yes.
Lordship.
Please call them.
That will be better.
Because only Mehrun-Nisa, only one school, and the PTI is also not correct, your lordship. Because
The petitioner is an assistant teacher.
Yes.
Of Chabiran-Nisa Girls Junior Basic School under Mathabhanga 1 Circle.
my lord, now she is in Kashiabari, number 2 Junior Basic School under Holdibari Circle.
Oh, now she is in. Petitioner is presently serving
Transfer.
as an assistant teacher in Kashiabari number 2 Junior Basic School under Holdibari Circle. Full stop. The petitioner has approached this court
My lord,
for
one indulgence in this. This is not a intra-district. This would be an inter-district because Holdibari falls under
Kuchbihar.
your lordship, from
It was the
Kuchbihar to
Jalpaiguri. Then the board is there.
Board. I have another
Board will be
matter.
there.
I saw interdisciplinary.
I'm extremely sorry. I tender my unconditional apologies.
So now you are the answering.
I have faith in her sincerity, so I thought I read it wrong.
I am extremely sorry, your lordship. This is the board is the
Kashiabari
So now you step into the issue.
under Holdibari Circle within the jurisdiction of District Primary School Council, Kuchbihar. The petitioner has approached this court praying for transfer to a primary school within the district of Kuchbihar. Has sought for transfer to a school, to any school situated within the jurisdiction of District Primary School Council, Jalpaiguri. Full stop. The petitioner alleges that in spite of her best efforts, she could not apply for transfer through the Utshoshri portal. Full stop. The learned advocate appearing for the petitioner submits that the petitioner be permitted to apply for transfer through physical mode.
Your Lordship, in case of primary, the application that she has made on 22nd of June 2026 in page 21, let that be considered by the board, Your Lordship.
Now, if that is, yes, Mr. What do you say?
Generally, when the Utsosri was not functional, other coordinate benches passed orders for directing consideration of the representation. Now, board thereafter, in accordance with the rules, calls for the medical reports in their own way. That is an internal thing. Now, in such circumstances, Millard, if Utsosri is not functional, the board can consider this in accordance with the rules.
But if Utsosri is functional, then
Millard, she has to follow the procedure.
she has to apply.
She has to apply or apply for a year.
She cannot
She has
apply
applied through physical form.
physical form.
Physical
and
form. In
What
that
is-
event, Millard will consider physically, not difficult.
The learned advocate appearing for the petitioner submits places reliance upon a division bench, places reliance upon a decision of the Honorable Division Bench in dated 13th of July 2026 in MAT 2381 of 2024 in the case of Priyanka Pradhan versus State of West Bengal and others, wherein the Honorable Division Bench has taken note of the fact that the portal is under repair and is not functional, and accordingly gave and accordingly permitted the petitioner therein to make application offline in terms of the transfer rules 2015 and the format prescribed thereunder. You have
already applied.
in this format,
There is no specific format. This is for
where it has been
secondary-
recorded
That
in
is
terms
for-
of the 2015 transfer rules and the
Your Lordship, for the secondary education, there is a specific format. For the primary education,
full stop
the
paragraph.
application would suffice, Your
The
Lordship.
learned advocate appearing for the petitioner, where is that application?
Page 21.
Page 20.
Submits that the petitioner has already applied
Page 20.
for transfer by a later dated 22/6/2026 in physical form. Full stop. The learned advocate appearing for the district primary school council. You are which district? Jalpaiguri.
Jalpaiguri.
Jalpaiguri submits that though the online portal Utsosri was temporarily suspended by notification dated 23rd of December 2025, but the same has become functional with effect from 1st of July 2026. Full stop. Thus, it is evident from the notification dated 30th of June 2026 that the online portal was not functional at that point of time when the petitioner submitted her application for transfer. Full stop. For such reason, this court is of the considered view that there cannot be any impediment for the respondent authority to consider the application praying for transfer by letter dated 22/6/2026. So accordingly, the
Respondent number 4, the secretary.
secretary West Bengal Board of Primary Education, being the third respondent, is directed to consider the
Secretary is the fourth.
secretary is four.
Fourth, your lordship.
The Secretary, West Bengal Board of Primary Education, being the fourth respondent, is directed to consider the representation of the petitioner dated 22nd June 2026 and to dispose of the same strictly in accordance with law. Any hearing is contemplated
Hearing is generally given.
after affording an opportunity of hearing to the petitioner, first of the and communicate the recent order to the petitioner immediately thereafter. The entire process shall be completed. Yes, also 4 weeks. Within a period of 4 weeks from the receipt of a server copy of this order, together with a photocopy of the representation dated 22nd of June 2026. So your objection has been taken care of.
Lordship, it's functional now. It's functional.
But it was prior to that.
Prior
Within
to
that time, it was not functional, admitted. Yes, I'm
Maybe
coming
you
after 5
report ছাড়া তুমি দিতে হবে।
তুমি কোড তুমি যাবে তো কোড দিয়ে আমি দেখেছি মেহেরুন আমার ওই ক্লায়েন্টের আছে তুমি মেহেরুন আমি কোন এরপরে কি 22 হবে
21
Lord, I'm for the petition.
21. Yes. My lord, as per the covering letter, my lord, it is scheduled to appear before your lordship on the 23rd of September. So we have asked for instruction. It's a police in action matter, my lord. By tomorrow, we are expecting the instructions, my lord.
Yes, what do you want?
Lord, I'm praying for transfer the investigation to any special investigation department. The 23 years old son of the petitioner have been missing and subsequently found in the nearby river. My lord, till date, none of the accused person have
Already
been.
you do one thing, you file a report with regard to the progress of the investigation. I'm keeping it in the next week.
My lord.
27th.
27th.
The petitioner has paid for transfer of investigation to an independent investigating agency. Full stop. The concerned investigating officer
This is my lord, the inspector in charge, Moinaguri Police Station.
the inspector in charge, Moinaguri Police Station, being the 8th respondent, is directed to file a report indicating the with regard to the allegations contained in this writ petition.
My lord,
Paragraph 27.
can it be, my lord, recorded that with regard to the progress of the investigation?
With regard to the allegations contained in the writ petition as well as the progress of investigation.
Grateful, my lord.
Lord, everybody service be kept.
We will service taken on record. Next.
Item number 22.
Yes.
My lord, this is my application, my lord. And my lord, I
Who
have,
is opposing you?
my lord, the answering respondents are the state, but I have also included the center and the CGST, my lord.
But state, who is appearing in revenue matters? You will be appearing, Mr. Bhattacharya.
No, revenue matters usually, my lord, Mr. Jagrati Mishra appears. Oh. My lord, he is on his legs and.
Who is engaged?
Mr. Mishra.
Mr. Mishra is there.
Yes, you are assisting him.
Yes, lordship.
Yes. Yes, what
My
is
lord, yes, ma'am. My lord, I'm placing my affidavit of service.
Yes.
My lord, in this petition, my lord, I'm challenging the show cause notice, the adjudication order, my lord, for being want of jurisdiction. Now, my lord, against the adjudication order, my lord, I have filed an appeal, but the appeal was belatedly filed. So it was dismissed on the ground of delay, my lord, which the statutory appellate authority has no power to condone. But that is not the issue, my lord. If my show cause notice and the adjudication order, my lord, is vitiated because of being lacking in jurisdiction, my lord, then the base of the list goes, and then, my lord, the appeal, whatever he has passed, it doesn't matter. Now, my
Not
lord,
at the jurisdiction. Why?
yes, I'm stating, my lord, on 4 grounds I have challenged the jurisdiction. First is, my lord, the case is the petitioner, my lord, is a registered taxpayer, my lord, who supplies materials for road building, and he is in the Raigon district, but under the jurisdiction of the central tax authorities of Shiliguri. My lord, may kindly come to page, I will show, my lord, page 43. My lord, page 43. Yes, my lord.
Yes. Yes.
Yes, my lord, page 43. Yes. Page 40. My lord, kindly see what is his administrative office. His administrative office is jurisdiction center. My lord, that is why I have made the CBIC as a party. State CBIC, Zone Kolkata, Commissionerate Shiliguri, Division, Dinajpur Division, Range, Bunyadpur Range. And other offices, my lord, are the state. But, my lord, the administrative office under whose jurisdiction, my lord, the registered taxpayer is, he alone can, my lord, he is the proper officer for initiating proceedings under section 73 or 74. Now, my lord, in this case, the show cause notice and the adjudication order has been passed by the Bureau of Investigation ITC investigation unit, my lord, of the state, my lord, which will be evident. Show cause notice টা কোথায় আছে? Show cause notice টা, my lord. Page-
Did you reply to the show cause notice?
Yes, my lord. I replied.
Did you
to the-
raise that point?
My lord, no, I could not because he is from the Mofassal area. He did not know the law. But my lord, since this is a question of law, my lord, which does not depend on any other facts, I can raise it at any point, my lord, for which I'm supported by the Supreme Court judgment. Now, my lord, kindly come to pages 52 to 59.
Yes.
My lord, if your lordship sees,
Yes.
he says that 57. 57. My lord, kindly come to, that is the full text of the show cause notice. My lord, it's
Page
page 57. 57. And
Yes.
my lord, it says Government of West Bengal, Office of the Special Commissioner, GST, Bureau of Investigation, North Bengal, ITC Investigation Unit. My lord, he has issued the show cause notice. This gentleman who belongs, that is the Deputy Commissioner, my lord, page 59. She belongs to this unit as a part of the Bureau of Investigation and ITC Investigation Unit state. Now, my lord, the order has also been passed by her. Now, my lord, I will place before your lordship section 6 of the CGST Act. What does it say, my lord? Wait. Section 6. My lord has a book, my lord?
Yes, yeah.
Section 6.
Yes.
No, my lord. Section 6(1).
May I?
Yes.
My lord, in this case, Central GST is also made party.
Yes.
As respondent number 5 and 6.
Yes.
But just now I have been informed by my colleague, no copy has been served upon the Central
We have
GST.
the copy if you want to.
No copy has been
You
served.
have not, sir?
Yes, I already
Served. It is in the.
No.
It is in my
Upon
lord.
the
the
Central
affidavit of
GST.
service.
I also can have a copy.
But just after.
But my lord, they are not the answering respondents. They are there to say whether what I'm legally saying is correct or not. And since I say
No,
that the
without any
central has the
instruction,
jurisdiction.
without any instruction, at least 1 day or 2 day
My
time
lord,
is
my lord.
required.
It will
At
not,
least,
they will not be affected, my lord, because they are not the answering
however, without
respondents.
going through the writ petition, how can I say that the
You-
department
the
will
order
not be
has not
affected?
been passed
It
by
is
them.
not possible for me.
My lord, the order.
No, order
I'm-
has been passed by the state authority.
State authority.
Yes.
Who is representing the state authority? You are
Mr. Mishra,
representing the state authority.
My lord,
Yes.
so they are there to say whether what I'm saying is legally correct
Yes.
or not. My lord,
Because they have not challenged your notice, your
Yes.
decision.
my lord,
Yes.
kindly my lord, 6 subsection 1. Authorization of officers of state tax or union territory tax.
Section 6,
6(1) of the Central Goods and Services Tax.
not WBGST.
My lord, central. Indeed.
GST.
My lord, both are parameter same, but still.
So I can look to section 6
My lord,
of the-
I'm breaking before your lordship, my book.
Yes, authorization of officers of central tax.
Section 6 to that. It is central though.
Yes.
Oh, it is central.
That is CGST টা নিয়ে নেবেন, বুঝলেন? CGST টা নিয়ে। WBGST, yes, section
Yes.
6.
Section 6, my lord. Section 6. Yes, there is a 3. That was 9. Central 6, my lord. It says authorization of officers of state tax or union territory tax as proper officer in certain circumstances. Without prejudice to the provisions of this act, the officers appointed under the State Goods and Services Tax Act or the Union Territory Goods and Services Tax Act are authorized to be proper officers for the purposes of this act. My lord, thereafter, subject to such conditions as the government shall on the recommendations of the council by notification specify. So, my lord, the central tax of the state tax officers can be proper officers, provided the government, the GST council approves it and a notification to that effect is issued. Now, my lord, I am submitting that the GST council has not issued any such a notification. I'm placing the notification which GST council has issued, my lord, which is at page 130.
130.
130, my lord.
Section.
Yes.
No, my lord, the issue is, my lord, whether when the center has the jurisdiction, whether there can be cross empowerment by the state authorities. Now, my lord, here is the central notification by which they would be empowered or cross empowered to take up matters which belong to the central jurisdiction. Now, my lord, in this circular page 130, my lord, what it states in 1 and 2, my lord, it says, of the total number of taxpayers below rupees 1.5 crores turnover, all administrative control over 90% of the taxpayer shall be vested with the state tax administration. So, my lord, 90% will belong to the state jurisdiction and 10% will belong to the central jurisdiction. In respect of total number of taxpayers above rupees 1.5 crore turnover, all administrative control shall be divided equally in the ratio of 50% each for the central and the state tax administration. My lord, if the turnover is more than 1.5 crore, then my lord, 50-50.
50%.
Now, my lord, kindly come to next page, paragraph 4. Suitable notifications regarding cross-empowerment of state and central officers under CGST, IGST, and SGST Acts respectfully are being issued separately. So they said they will issue separately. My lord, they have not issued any notification for cross-empowerment of taking up, my lord, this adjudication functions. My lord, the only notification which they have issued, both state and center, my lord, the center has issued it in page 132. My lord, that is the notification. My lord, it says, in exercise of the powers conferred by subsection 1 of section 6 of the Central Goods and Services Tax, on the recommendation of the council, the central government hereby specifies that the officers appointed under the respective state goods and services tax 2017 or the Union Territory Goods and Services Tax Act, who are authorized to be proper officers for the purposes of section 54 or section 57(5) of the said acts by the commissioner of the said acts shall act as proper officers for the purpose of sanction of refund under section 64 or section 65 of the CGST Act read with the rules. So, my lord, they have been authorized to be proper officers only for the purpose of sanctioning refund and not for any other purpose. My lord, this is the central notification. Similarly, my lord, at page 153, if your lordship sees, the state has issued a similar notification cross-empowering the central authorities to sanction refund. My lord, it says in exercise of the powers conferred by subsection 1 of section 6 of the West Bengal Goods and Services Tax Act, on the recommendation of the council, the government is pleased hereby to specify that the officers appointed under the Central Goods and Services Tax, who are authorized to be the proper officers for the purposes of section 54 or section 55 of the CGST Act, by the commissioner in the board, shall act as proper officers for the purposes of sanction of refund under section 54 or section 55 of the WBST Act. So, my lord, what it means that if a taxpayer is assigned the central jurisdiction, the state only can, my lord, is cross-empowered to sanction his refund. Similarly, my lord, if a registered taxpayer is under the jurisdiction of the state officer, then the central officers will only be the proper officers for the purpose of sanctioning refund. Now, my lord, this matter came up before the Madras High Court, my lord, before the division bench of the Madras High Court. And the Madras High Court has clearly laid down that they have no jurisdiction. They have no jurisdiction, my lord, no cross-empowerment. If a person is assigned the central jurisdiction, the central officers will. My lord, this is the division bench judgment of the Madras High Court, my lord. My lord, kindly come to, my lord, before it he has dealt what the GST Council had stated, etc. My lord, kindly come to the relevant paragraph.
This is a single bench judgment.
My lord, it is single bench division. My lord, single bench judgment. Single bench, my lord, I'm sorry.
Yes.
I'm extremely sorry.
Yes.
Madam. It's a single bench. This is another, but I'm sorry. Yes, my lord, I'm sorry.
Yes.
My lord, kindly, my lord, paragraph 61, 62, 63 of the judgment, my lord. My lord, may I read out, my lord? 61, my lord. Paragraph.
Yes.
He discusses all what as the GST councils had said earlier. The section 6(1) of the respective GST enactments empowers government to issue notifications on the recommendations of the GST council for cross-empowerment. However, no notification has been issued except under section 6(1) of the respective GST enactments for the purpose of refund, although officers from the central GST and state GST are proper officers under the respective GST enactments. So, my lord, for cross-empowerment only, they have been given, notification has been issued, my lord, which I showed your lordship. That is page 150 and 150. 132. No, 51. She should give the record. 151, 152. My lord, that is, are proper officers. Then he says, my lord, since no notification have been issued for cross-empowerment with the advice of the GST Council, except for the purpose of refund of tax under Chapter 11 of the respective GST enactments, read with Chapter 10 of the respective GST rules, impugned proceedings are to be held without jurisdiction. Consequently, the impugned proceedings are liable to be interfered in these writ petitions. Now, my lord, paragraph 63. Thus, if an assessee has been assigned administratively with the central authorities, pursuant to the decision taken by the GST Council, as notified by circular number 12017, bearing reference number cross-empowerment dated 29/2017, the state authorities have no jurisdiction to interfere with the assessment proceedings in absence of a corresponding notification under section 6 of the respective GST enactment. My lord, this notification is in page 130, which I showed your lordship, my lord, where it speaks that for cross-empowerment, separate notifications will be issued. He's saying, my lord, that no separate notifications have been issued.
Yes.
My lord, this is the notification, my lord.
So
That
here,
means it's
according to you, you are under the central
the
authority.
central authorities. So my
Please
first,
show me that page.
yes, my lord, page 43.
Page 40.
43. My lord, kindly see. This is from their side. Administrative office, jurisdiction, center, state CBIC, zonal Kolkata. This is his jurisdiction. That is division Dinajpur. Miss his other offices. That is his main jurisdiction. His administrative office is his main jurisdiction. My lord, that is why I've implemented, my lord, the say CGST as well as the union of.
So the jurisdiction will be on the basis of the administrative office or the place of business.
My lord, administrative office, and he comes within his, because of his place of business, he comes within the division, my lord, commissionerate Shiliguri, division Dinajpur, and range is Bunyadpur range.
No, where is the administrative office? Administrative office is situated where?
Here, my lord, his administrative office is situated in
Dinajpur.
Dinajpur, Bunyadpur region, and
Yes.
Shiliguri commissionerate. He is under the overall jurisdiction of the Shiliguri commissionerate.
No, the administrative office is within the jurisdiction of the central,
Yes,
and the other office is within the jurisdiction of state.
state. But this,
So how this, with regard to this, which is to be considered administrative of the other office?
administrative office.
Where do I find that?
My lord, that is, it says that who have been assigned that
No,
jurisdiction.
assigned is here.
Who,
It
my lord,
says
kindly see,
center is with regard
has
to
been
the.
assigned administratively with the central tax authorities. My lord,
Where-
paragraph 63. Paragraph 63 of the judgment of Madras High Court. Paragraph 63. That's if an assessee, my lord, my junior is also appearing, assisting me.
Paragraph
63. Thus, if an assessee has been assigned administratively with the central authorities, my lord, his administrative office is the center. My lord, kindly see, thus if an assessee has been assigned administratively with the central authorities.
63.
63. Pursuant to the decision taken by the GST Council as notified by circular number such and such. My lord,
Yes, yes, madam, what do you say?
My lord, apart from this, there are two or three other grounds.
Central GST should be the answer.
Why central GST? You have issued the notice. You have to show that you have the jurisdiction to issue the notice. Central authority has not issued any notice. Entire adjudication and the notice is by you.
Oh, another thing, my lord, in the annexure P2, it is clear that the principal place of business is at PWD Para,
No, but
Gangarampur.
it has been administratively, it has been assigned to the central authority. That's the judgment of the Madras High Court.
And my lord, the initiation has been done by the Bureau of Investigation, ITC unit of Shiliguri range. So that is why I have come within your lordship's
My
jurisdiction.
lord, detailed hearing is necessary, my lord.
Yes, my
Kindly allow me 1 day accommodation because as per submission, it is clear that there is some involvement of the CGST authority also.
But they
So
have
I
not
will make
issued
my
you-
submission, and this is a judgment of honorable single bench.
Appearing for the
This is not the
petitioner,
division bench judgment, not our high court judgment.
has challenged the proceedings initiated by the state GST authorities, by WB GST authorities. Full stop. She submits that the WB GST authorities lacks jurisdiction to initiate, to issue the show cause and to proceed further when the petitioner has been administratively vested with the central authorities. Full stop. In support of such contention, she placed reliance upon a decision of the Honorable Madras High Court reported at 2024 160 taxman.com 771 within bracket Madras in the case of TVL Vardhan Infrastructure versus Special Secretary, Head of the GST Council Secretariat. Mr. Boni Clanet, advocate, appears for CGST authorities and prays for an accommodation. To establish this matter, when
It will be better if my lord fix the matter on Monday, my lord. Monday, because I have to, and moreover, one thing, my lord.
It's only the question of jurisdiction. P2. It's only the question of jurisdiction. That's the notice.
My lord, the annexure P2 administrative office is situated within zone Kolkata, but commissioner is Siliguri, but zone is Kolkata. And the division is Dinaspur division, Bunyadpur. So this petition, whether this petition is maintainable before this court or not, it is required to be clarified.
So that's the only point.
It is required to be clarified.
I'm
It
keeping
is a
it day
matter
after
of
tomorrow.
principal bench.
I'm keeping it day after tomorrow. That's the only point.
It
You can make your
is a matter of
submissions
principal bench, my lord.
Short point.
Friday. My lord, kindly Friday.
Not Friday.
My lord, a day after tomorrow, my lord, I humbly pray, my lord, I have a fixed matter, my lord.
When?
On Thursday, day after tomorrow.
Where?
My lord, I have to do online on to Gujarat High Court. Or up to virtually appear.
Tomorrow it is not possible, my lord.
Short point. Only this is the point of law. Yes. Yes. Tomorrow. Yes. Next.
Give a copy of judgment.
My lord.
Please give him a copy of the
copy of
My lord, I may appear virtually tomorrow, my lord.
My lord, in that case, kindly fix it Friday. Friday, it will be better for me to appear physically before my lord.
Yes.
I'm grateful, my lord.
Judgment.
Judgment
কি হলো?
Judgment
এই বইটা দিয়ে দেবো।
আচ্ছা। Yes, next. Grateful.
Copy দিবি?
Item number 28.
28, yes. Yes.
Judgmental property.
Yes.
And if it may please, Your Lordship, there's a consignment. 28, I think 28. Your Lordship will see the impugned notice. There's a consignment that has been seized, and the assessee has sought provisional release. It's not been decided for 2 weeks. The assessee has challenged the seizure and has come before this honorable court because upon inspection of this, the seizure procedure and the seizure report itself, there are various deficiencies that have come to surface. And it's something that the assessee wishes to bring to the attention of this honorable court. If Your Lordship comes to page 50. 50.
Yes.
So Your Lordship will see this is the first page of the seizure memo. So the first thing that may come to Your Lordship's attention is date and time of interception in the tabulation.
So you said you wanted provisional release. Did you make a prayer for
Yes,
provision?
yes. That's
Where
there.
is that?
Page 53, my lord.
Page 53.
Yes.
What's the decision on this?
They have not decided.
So I direct them to take a decision on this provisional release.
My lord, perhaps with some additional directions if necessary, because I would like to bring certain matters to Your Lordship's attention, the way that they've carried
Then
out
it
the
has to
seizure.
be on affidavits. If you want to challenge the entire thing, then it has to be on affidavits.
I won't challenge anything. Let them decide it.
Provisional release, I can direct them to decide within a certain
Let
time.
them decide it. I wish to bring certain matters. If certain qualifications can be, if they are deciding it, that certain matters be gone into at least. If I can, instead of keeping it very blanket or open for them. Because what has happened, my lord, is that usually when there is a seizure, there has to be a reason to believe. Now here what has happened is they've not challenged the documentation. They've not challenged the route which the vehicle has taken through FASTag data or anything of that sort. What the superintendent has carried out the seizure. He has himself taken samples of goods in his customs office. He has boiled the samples. He has observed certain chemical reactions, and he has used that as a basis for the seizure after making these observations. Now, he is not a chemical examiner. These tests, these samples, first and foremost, they have to be taken before a magistrate. And they have to be sent to the CRCL or the recognized laboratories where these are tested. And generally, before the reasons to believe have to precede the seizure. He has carried out an inspection on his own. He's done the chemical examination, and then he's saying that because of this, I'm seizing. And if Your Lordship sees there are two lines that this perhaps has to be clarified. If Your Lordship sees ground number 1 in that seizure report, page 50. It's the first page of the seizure report itself.
Yes.
Your Lordship will see ground Roman 1.
Yes.
It says the recovered areca nuts are dark brown to blackish in color, whereas Indian origin areca nuts are generally light to medium brown and may possess a reddish hue. Now Your Lordship will see in the next page, Roman numeral 5. It starts with the words during examination. The recovered areca nuts and betel nuts appear to have been treated with artificial red. So he's just said that it's dark or it's blackened without any red hue. Now he's saying it's artificial red, coloring intended to conceal the original whitish appearance. How does black become white and red in between? And he's saying that they resemble Indian origin, reddish areca nuts, and that the quantity of dried areca nuts was subject to a simple boiling water test. How is he saying this? And there are fundamental contradictions in his very observation. He's calling something black without red hue. Then he's saying that it is of a reddish hue, but it is an artificial color with an underlying white color. Now, white is not black. And if it's not red, it's the other. So what is it? There's no clarification. And he's done a boiling test. Is he competent to do that? So even if the provisional release application is pending, these are issues which they have to address. The sampling has to be done before a magistrate. It has to go before a proper authority.
Yes, so where is the provision for, where is the?
110
provision for
1B,
provision?
section 110 1B.
Yeah, my lord. May I submit, my lord?
Please give me one.
Your Lordship, will see subclause 1B of section 110.
Yes. Customs Act.
Yes.
Customs.
My lord, in section 110 1G. 110 is the seizure and 110 1B is the process for certification.
ওটা এখানে বলে লাভ নেই, অসীম চেয়েছি অসীম বলে দিও, আমি জানি ডিসিশন আছে।
Yes. So you have applied under 110 capital A.
So if your lordship,
That is the provisional release.
yes, I have asked for provisional release.
Yes.
Now what they are required in the meanwhile to have done the sampling and the testing,
Yes,
and in
yes,
terms
yes,
of section 110 1B subclause C, if your lordship sees.
Yes.
Instead of doing that, the superintendent himself has done the sampling. And he's given observation. And that has become the basis for the reasons to believe. It's a post-fact reason to believe. First of all, an eye test,
No, there
an
are
eye
two
examination
things.
cannot be
If you are
sufficient.
challenging this, then it has to be decided on affidavits.
Affidavits.
Without the affidavits, how can
Well,
I-
it's become a problem for us also. We want to participate in the alternative forum. But the way that they have carried out the seizure is so
Raise
anomalous.
all points before that.
Very well.
My lord,
But,
my lord.
would your lordship be so gracious to give them a direction to at least do the sampling in terms of 110 1B?
My lord,
Under the,
let
under
me
this
submit, my lord.
statute, they are bound to do that.
If they don't, if they're not doing it so far.
Then you can challenge that. Have you challenged that? Then it is to be decided on affidavits.
Very well.
Then it is to be decided on affidavits. If you have challenged that they have not acted according to the procedures, I have to.
They can
give the-
clarify if they have done it.
That's
in
why
the-
I'm willing
Yes,
to
ma'am.
make my submission. My lord, as per section 110, seizure will be made by the proper officer. And section 110 1B is the process for certification of correctness of inventory. And the
Sampling.
The application will be filed before the jurisdictional magistrate. That is the procedural. And at the time of certification by the magistrate, another sample will be taken in presence of the magistrate. And that sample report will be sent again to the laboratory for the purpose of testing. Here in this case, on 4th, seizure was made on 4th, if I am not wrong, on 4th seizure was made, and the 4th of this month, 4th July. And on 9th, they have filed application for
10th.
provisional release on 9th, just immediately after 5 days. But this, as per statute, 110 2 proviso, the statutory period is 6 months, and it may be extended for another period of
That is for
another 6 months. That
issuing
is
show cause
altogether
notice.
1 year.
That is for issuing show cause notice.
Yes.
So no one, we are not, the show cause can be issued
let me
later
finish,
also.
let me please.
Why is your lord?
Before
misleading?
issuance of show cause notice, the provisional release can be made as per section 110A.
No, this is
These are perishable goods.
110(2). If that is notice is not issued within that time, then you have to return that. That's
Yes,
the,
that is for show cause. We are not interfering with show cause.
We have to issue the show cause notice.
yes.
My lord, in this case, we have already, just today morning, I have received this document that already we have filed an application. Already we have instructed the Learned Council of Jalpaiguri Court for filing an application under section 110(1)(b). That is on 13/7. This process is required to be completed before release or any provisional release or any type of further procedure. The investigation is going
Yes, they have
on.
done that on 13th of July. They have approached before.
Very
the
Yes, yes, yes.
magistrate.
Moreover, today is the date fix. I have a summon which was issued upon the owner of the goods. And today is the date fix for taking evidence, for taking statement of that owner of the goods. Today is the date fix in view of that summon.
So this procedure they are
This
performing.
procedure are
So I'm directing the provisional release application to be considered in
Very
accordance
well.
with.
Your lordship will kindly fix a time frame. If your lordship will kindly, because these are perishable goods, they collect bacteria and fungus.
But
My lord,
only one
my
thing,
lord may pass a direction upon the jurisdictional magistrate for entering the application within a short period. Because if the jurisdictional magistrate will not fix any date for certification of the seized goods, so it is not possible for us to bring any report.
yes, how soon can you decide this application for provisional release?
After immediately after the certification, as well as the report from the laboratory.
Yes, certification, how much time it will take?
At least 1 month it will take.
1 month.
At least
Why?
1 month.
Why?
Because the jurisdictional magistrate they are so busy, they are not giving.
They are so busy.
Yes, the magistrate.
My lord, in
So,
the,
so a direction may kindly be given, my
my
lord.
lord, in the past,
I'm also
Justice
praying for a
Aniruddha Rai,
direction.
Honorable Justice Aniruddha Rai had given in the past 2 weeks. And they've been able to complete it within 2 weeks.
That's why I'm submitting that the direction may kindly be given to the jurisdictional magistrate.
You have not approached the court.
No, I have already approached.
You have not approached this court for a direction upon the magistrate.
Yes, sir, I'm submitting.
You are an authority, you can approach the magistrate for an expeditious,
Expeditious certification of the.
that you do there. Make a prayer before the magistrate
Already I have made prayer.
for expeditious certification procedure.
Alright.
Uh,
Moreover, the report is required to be.
the petitioner,
On the laboratory.
the petitioner has challenged the where is this
Page 50, my lord, seizure
Page
order.
50 has challenged the Caesar memo cum Caesar list issued under Section 110 of the Customs Act 1962 in this writ petition. First up, petitioner also applied before the concerned authority under Section 110 capital A of the 1962 Act, praying for provisional release of the articles, of the seized articles. First up, the learned advocate appearing for the petitioner submits that the respondent authorities have not taken steps in accordance with submits that after the goods are seized, the authority is under a statutory obligation to submit an application before the concerned jurisdictional magistrate for the purpose of certifying the correctness of the inventory so prepared, and also for drawing representative sample of goods in the presence of the magistrate. First up, he submits that the Caesar memo and the Caesar list, as well as the entire procedure, is liable to be set aside for such statutory non-compliance. First up, the learned advocate further submits that the respondent authorities have not also communicated, have also not decided the application filed by the petitioner praying for provisional release of the seized articles. First up, Mr. Bonik, learned advocate representing the representing the Customs Authority, submits that the goods were seized only on 4th of July 2026, and immediately thereafter, the concerned authority approached the jurisdictional magistrate for certification of certification as to the correctness of the inventory so prepared, and to draw samples, representative samples of the goods in the presence of the magistrate. First up, date on 13th of July 2026. First up, he submits that all the procedures as contemplated under the 1962 Act, more particularly Section 110 within bracket 1 capital B bracket closed, has been strictly followed by the respondent authorities in the case on hand. First up, faced with such situation, the learned advocate appearing for the petitioner submits that for the present, the petitioner is seeking a direction upon the respondent authorities to consider the prayer of the petitioner for provisional release of the seized articles. First up paragraph, record reveals that an application seeking provisional release of the seized articles was submitted before the authorities by a letter dated 10th of July 2026, which was received by the office of the concerned authority on the said date. First up, in view of the in the light of the submission in the light of the submissions made by the learned advocates for the respective parties, WPA number such and such stands disposed of by directing the Joint Commissioner, Joint Commissioner, Customs within bracket preventive, Kolkata, being the second respondent, to consider the application dated 10th of July 2026, seeking provisional release of the seized items and dispose of the same by passing a reasoned order as expeditiously as possible, but positively within a period of 3 weeks from the receipt of a server copy of this order, together with a copy of the application dated 10th of July 2026.
Regarding
Deeply obliged.
certification, regarding the certification, it will not be possible.
Do that approach it will be open to the respondent authorities to approach the concerned jurisdictional magistrate for necessary orders,
Certification?
in the
fix a
light
date,
of
my
the provisions contained under section 110 within bracket 1B of the 1962 Act.
Within a, kindly fix a date, my lord.
Not that. You have not approached.
We have already filed application before.
You have not approached before this court. How can I grant fair on you?
No, we have filed application for certification.
That will be done. Please, I've given you liberty to approach the authority with regard to that.
In that case,
Approach the
kindly-
jurisdictional
kindly fix
magistrate.
it At least 4 weeks, my lord. Instead of 3 weeks, at least 4 weeks can be.
Why do you apprehend that the magistrate will not do this within
They are so busy and heavy.
No, everybody is busy. Yes, next.
29.
My lord, I'm appearing in this.
29, my lord, I have not yet received any copy of the writ petition. Just today morning, I have been instructed to.
Yes.
My lord, I'll let my learned friend take comprehensive instructions to allow him to perhaps take better instructions, if I may be given the indulgence to make preliminary submissions. My lord, this is the affidavit of service. I'm not praying for relief immediately. Your lordship will see the impugned order is in page 80. So this is also a
80.
consignment, 80, my lord. This is also a consignment which was detained, and there was a direction by Honorable Justice Hidayat to dispose of the application for provisional release within a time frame.
Provisional release.
Yes, my lord. So this is it's a very similar sort of case. It concerns a consignment of areca nuts. And here the decision that has been taken is that release has been rejected outright. Now, in the meanwhile,
on what ground?
On the ground that the assessee has not provided, allegedly, procurement records. That's all. Now, in the meanwhile, the samples which they had taken.
For that, samples that have been taken?
They went to the ARDF, the Areca Nut Foundation Development Research and Development Fund. So they have returned a report saying that the samples indicate that the consignment is of Indian origin.
Indian origin?
Yes.
Yes.
Which takes the matter completely out of the purview of the Customs Act. So they have passed the order without referring to that report. And they have said the assessee has purportedly not submitted procurement records, which is actually not mandated under the law. There's no requirement anywhere that procurement records have to be produced.
Please show me that.
Yes, my lord. So first and foremost, my lord, I'm placing the a short compilation of precedents. Your lordship will see this is an order of the honorable bench in an almost identical case. Your lordship will kindly peruse the contents of the order.
No, please show me that it's report says it's of Indian origin.
Oh, right. Yes. So this is in page 61 of the writ petition.
Yes.
So if your lordship sees the observation, the conclusion that is provided at the last paragraph of the report, the sample of areca nuts, betel nuts received from the Superintendent of Customs, Office of the Superintendent of Customs, Birpara Customs, Makrapara, under its seal has been tested and found that it is red, whole type of areca nuts, betel nuts, and resemble to Indian areca nuts, betel nuts. The nuts are good in quality. So the identification of origin is that they are Indian. Yes.
When the articles were seized?
The articles were seized on 22nd March 2020. No, let's see. So 24th March 2026, this is in page 44, the detention memo.
24th of March 2026.
Yes, my lord. Bullet issued.
Where is the order of the adjudicating authority?
Yes, my lord. This is in page 80. 80.
80.
Yes, my lord.
There's a provision of appeal.
This is a provisional release order. And
There's a provision of appeal.
my lord, now the position is that because it's an adjudicating authority who is passing this order, there's a right of appeal available. However, if the Customs Act has no application, there is a major jurisdictional issue which serves as an exception to the alternative remedy principle, which is why the petition is here. Because if the goods are not even of foreign origin, the Customs Act won't apply. And if they report their samples, they have got the report. It is showing that it's of Indian origin. What can we do? And thereafter, they are refusing to release the goods. If they want, they can issue the show cause notice also after this. What is the harm in releasing the goods now?
But that report was not considered.
It was not even discussed. It was not discussed. They've discussed the FSSAI report, which says that they are unfit for human consumption because as it is, dried areca nuts are unfit for human
I
consumption.
find National Food Laboratory.
That's the FSSAI. So that is for fitness of human consumption. So
Yes.
here the SSC is selling dried areca nuts. They are meant for industrial use. SSC is not disputing that. SSC wishes to use it for industrial purposes only. That has nothing to do with Customs Act. But the most important thing is the suspicion was that this is of Indian foreign origin and therefore they seized it under the provisions of the Customs Act. Now their test reports are saying they have sent the samples. Now they have this report with them. What is the purpose of denying the provisional use? There has to be some basis.
Yes,
At least 1 day time is given. No, I have not gone through the copy.
Heard the learned advocate for the petitioner. So, sir, the petitioner has challenged the order of provision, has challenged the provisional release order under section 110 capital A of the Customs Act 1962 passed by the adjudicating authority. First up, Mr. Bonik, learned advocate, appearing for the CGST authority, for the Customs Authority, seeks an accommodation to revert back with necessary instructions when list this matter on Thursday under the heading motion.
My lord, would it be possible to keep it next week?
Next week, Monday?
On Monday? Monday?
Monday.
Deeply obliged, my lord.
Thank you. Next.
The copy টা আমাকে দিন। Item number 31.
Detailed copy ছিল না?
নেই তো, আমি ওই জন্য তো বলছি।
31, who is appearing? None appears for the petition.
The petitioner, my lord, the service has not yet been, my lord, affected, my lord. But I have initiated, my lord. Kindly make it, my lord, next week, my lord.
The learned advocate appearing for the petition submits that service is yet to be the service of a copy of the petition is yet to be effected upon the respondents. Post up, petition is directed to serve a copy of this petition upon the respondents and file an affidavit of service on the next day. 28th?
Yes.
Is this matter of 28th? Yes, next.
Good.
Number 32. 32, yes. The petitioner has alleged willful and deliberate violation of the order dated 4th of April 2025. First up, petitioner is directed to serve a copy of this contempt application upon the alleged contemners and file an affidavit of service on the next date, 29th. Next. Item 34.
Lordship, this is contempt application, land acquisition matter.
Service, 29th. Yes, next.
Lordship, this is first turn. First hearing.
No, I could not follow.
Lordship, this is first turn.
You serve.
Okay, Lordship.
I'm directing you to serve. This is appearing for the first time.
Yes, Lordship.
I'm directing you to serve. Please serve. I'm keeping it on 29th.
Yes.
Yes. Next. 36.
Same, Lordship.
Same. Next. 36. 38.
Till 43, same.
Same.
Yes, Lordship.
Same orders. Till 43. Same. Service 29th. Next.
Lordship, kindly fix this matter on Monday.
Monday, complete service. Some time is to be given. I'm keeping it on 29th. Bollam to. 29th. Yes. Next. 44. 44. Yes. 44. 44 din. Service 29th. Yes, next. 45. 45 to read petition. 46. 46. 46. 44 serve. 29. 46.
My lord, I am seeking the liberty to serve the opposite parties, my lord.
You are?
My lord,
You are for the petitioner.
my lord.
Serve 29. Service 29. Upon the arrest. Next.
My lord, 32, my lord, item 32, my lord, the order was already complied. 32, I think.
32 complied?
Yes.
Achha, please.
Yes.
Yes, 48. 48. 48. First time.
No, my lord, it was a contempt petition.
Yes, contempt petition first time.
First time.
The petitioner appearing in petitioner appears in person.
My lord,
The petitioner
the order
is
has been complied.
order has been complied.
But very negligently and after much delay. That is why
So complied with.
there is no reasoning, my lord.
The
There is
petitioner appearing in person submits.
complete miss of reasoning. My lord. There is a direction that it has to be a reasoned order, but you can see
If
the
that
order.
is not a reasoned order, you challenge that.
I know, but this is a
There is
very,
order.
very bad harassment, na? That I have to file a contempt petition even after not
But
compliant.
now the law is if the order has been complied with, where is that order? Reasoned order, please show me.
You can see. Specifically, my lord, page 1, third para. This is the statement of the respondent executive engineer.
This is an application alleging, this is a contempt application alleging willful and deliberate violation of the order dated 3rd of November 2025. The petitioner appearing in person submits that that an order dated 1st of July 2026 has been forwarded to the petitioner very recently. First of all, he submits that the order was not communicated to the petitioner within the time limit indicated in the order dated 3/11/2025. First up, this court finds that by the order dated, you are for the contemner.
Yes, Your Lordship, it has already been complied and
Yes,
it
yes.
has been
But
communicated.
you have not complied within time.
Yes, Your Lordship, but it has been complied and hearing, it
Ila-
has been
Tibola?
communicated to the petitioner.
3/11/2025, the district magistrate Kuchbihar was directed to consider the representation of the petitioner dated April 3, 2025, and to dispose of the same by passing a reasoned order. First up, though the petitioner appearing in person may be justified in submitting that the order was that the reasoned order was not passed within the time limit as fixed by this court, but since the reasoned order has been passed, this court is of the considered view that the order and directions contained in the order dated 3rd of November 2025 has been substantially complied with. First up, the contempt application accordingly stands disposed of. আচ্ছা ওখানে একটা করে দিন এখানে learned advocate for the alleged contemner appears and submits that the the directions contained in the order dated 3/11/2025 has already been complied with. First up, if the petitioner is aggrieved by the reasoned order, it will be open to the petitioner to take steps in accordance with law. I'm keeping this copy.
Yes, keep. I have the original.
You have the original. A copy of the order dated 1st of July 2026 is taken on record. Disposed of. Yes, yours is 32. 32 টাতে একটা order record করে 32 টাতে ওই সার্ভিসের অর্ডারটা কেটে দিয়ে লিখুন। The learned advocate appearing for the petitioner submits that the directions contain দেখি ফাইলটা দিন।
April 2025 order.
That the directions passed by this court in the order dated 4th of April 2025 in WPA 394 of 2025 has already been complied with. First of such submission is placed on record. First of accordingly, CPAN number such and such stands disposed of. Thank you.
Yes.
Item number 50.
No, I am for the petition. My lord, yesterday your lordship heard the matter. My lord, petitioner.
Lordship, before we start proceeding, may I submit one thing, Lordship? We got the instruction, Lordship, but the instruction is not satisfactory, Lordship. I called the officer at 4:30 today, Lordship. Can you fix it tomorrow, Lordship?
So what is this matter?
My lord, in this matter, the petitioner have been suspended due to a my lord criminal case. Subsequently, the criminal case has been.
That matter which yesterday. Yes, the officer
As-
is coming. She will be
as
getting
your
it tomorrow.
Good.
On the একটা উপরে লিখে দিন, it has been pointed out that there is a typographical error while recording the order dated, while recording the order passed yesterday, বলে কালকের ডেটটা ব্র্যাকেটের মধ্যে লিখে দিন, wherein the date of the order was wrongly typed as 20/07/2025 instead of 20/07/2026. Let such error be rectified. Full stop. Ms. Singh, learned advocate appearing for the state, submits that though she has received instructions, but she requests further instructions in this matter. Full stop. On the prayer of the learned advocate for the state, list this matter tomorrow under the same heading. Yes. Call the next matter.
Item number 51.
For the petitioner.
Yes.
We are lordship.
This matter is laid by learned AAG. Kindly sort pass forward, Lordship, please, about
Yes, what is this matter?
Matters relating to the petitioners are full-time voluntary teachers. They are working as assistant teachers and under Golkhanland
All right,
Territorial
possible.
Authority.
Yes. Next.
Item number 52.
For the state. The lordship was pleased to take it up yesterday. I raised the point of maintainability. My learned friend was not without brief. Your lordship was pleased to give your lordship's file to him. He is not here. Kindly seize the prayer, my lord.
When this matter was taken up yesterday, we'll calculate there. The learned advocate appearing for the petitioner prayed for an accommodation. First up, however, when the matter was subsequently called on yesterday, the learned advocate did not appear. Full stop. Paragraph. Today, when this matter is taken up for hearing, none appears for the petitioner. First up, Mr. Bhattacharya, learned additional government leader submits that the submissioner raises an objection as to the maintainability of this instant writ petition in view of an alternative remedy. In view of the alternative remedy under section, what is the corresponding section?
I just kindly get me. My lord, sections 84, 85 where proclamation can be.
You are appearing?
Yes, my lord.
So now what do you want?
Well, any reasonable order may be passed by your lordship.
I'm expediting the investigation is.
Investigation is, no, trial is started. My lord.
Trial has started.
Trial
Travelers comments.
Then
Nothing remains of.
what remains? What was your prayer here?
My lord, he has prayed for arrest of the principal accused.
Acha.
One.
So now that prayer has become
Second, my lord, departmental proceedings against the police officers.
This writ petition has been filed praying for execution of the warrant of arrest issued by the Chief Judicial Magistrate Kuch Bihar by order dated 31st of March 2026. Full stop. When this matter is taken up for hearing, the learned advocate appearing for the petitioner submits that today, date, the principal accused has been granted anticipatory bail by the Honorable Division Bench,
Coordinate bench of this.
by the coordinate bench. Full stop. Paragraph. In view thereof, nothing remains to be decided in this writ petition. Accordingly, the same stands disposed of.
Grateful.
Yes, next.
Item number 53.
Grateful.
My lord, I beg to appear on behalf of the petitioner. Am I audible to your lordship?
Yes, audible, visible, both.
Yes, my lord. I'm grateful to your lordship.
Yes, yes, Mr. Laidi.
Transfer application, page 47. Primary intra-district transfer. I am praying for consideration by the concerned DPSC.
Page 40.
47.
47.
Yes, this is District Primary School Council will consider.
Yes.
Yes, Kuch Bihar.
DPSC will consider.
Yes, my lord.
Yes, who is for DPSC?
It has been solved, my lord.
No. Who appears for DPSC? This is which DPSC? Kuch
Bihar.
Bihar. Yes, who appears for DPSC Kuch Bihar? Mr. Bhattacharyji, you are appearing.
We don't.
When is she?
He usually appears virtually, my lord.
No, she was Musumi.
No, Musumi Goel, my lord.
Ashwin. The petitioner who is presently serving as
assistant primary teacher.
Where?
School is at, my lord.
Khaterbadi Deshbandhu.
Yes.
Who is presently serving as an assistant teacher in Khaterbadi Deshbandhu first phase AP school under Mathabhanga 1 circle has applied for transfer to a different school within the same district.
Yes.
Full stop. The petitioner submitted submitted an application for transfer through physical mode by an application dated 20th of February 2026. So Mr. Laidi, learned advocate, appearing for the petitioner, submits no decision on such transfer application has been communicated to the petitioner till date. First paragraph. State is represented by its learned advocate. First up, in spite of service, none appear. Where is the evidence of service file? Every service file in court today is taken on record. In spite of service, none appears for the District Primary School Council, Kuch Bihar. First up, paragraph. Without entering into the merits of the claim made by the petitioner in the application dated 20th of February 2026, WPA number such and such stands disposed of by directing the
6.
My lord, it would be
chairman.
My lord, kindly mention chairman or chairman in charge, because presently chairman may not be available. So presently under DI,
by directing the chairman District Primary School Council, Kuchbihar, to consider the transfer application dated 20th of February 2026 and to dispose of the same by passing a reasoned order and communicate the same to the petitioner immediately thereafter. Full stop. The entire exercise shall be completed as expeditiously as possible, but positively within a period of 4 weeks. 4 weeks from the receipt of a server copy of this order, along with a copy of the application dated 20th of February 2026. So, sir, in case the regular chairman, in case the office of the chairman of the District Primary School Council, Kuchbihar, is vacant, the chairman in charge shall consider the same and pass orders accordingly.
Grateful.
Grateful, madam. And all consequential steps will be taken.
That will be taken. Transfer application, all consequences steps thereafter will be taken.
Yeah. Grateful.
Yes,
Much
next.
obliged. Grateful.
Item number 55.
My lord,
Yes.
in this matter, my lord,
Please, my
I am
lord.
being led by Mr. Pulfrit Verma, who is appearing
Yes.
both.
Please, my lord.
Yes.
My lords, may recall that this matter was taken up yesterday, my lords, when your lordships
Yes.
were apprised with the fact that the show cause notice and the order under section 129(3) was passed on the very same date. That is much
Yes,
prior
who
to
is,
the
My lord, state was
personal-
representing yesterday. They took time
who
to
appeared
sort
for
out.
the state? Yes, yes, Mr. Vish.
Yes, Lord, as far as that is concerned, Lord, it was done before the. Oh, it was done before that time for the super notice expired.
Then, just to be set aside. Where is that order? Please show me the
My
show
lord,
cause
the-
notice.
My lord, the show cause notice is at page 48, 47 and 48, my lords.
And where is the order of adjudication?
My lord, it's at page 51. It starts with page 51 and the element is at page 54 and 55.
54 and 55.
Yes, my lord. This is the detailed order and the summary order is at page 51. My lord, the relevant provision is section 129(4), subsection 4.
Yes. The petitioner has challenged the order of the Deputy Commissioner of Revenue, State Tax, Bureau of Investigation within bracket North Bengal, Alipurdua Zone, Alipurdua. Dated 29th of March 2026 under section 129 within bracket 3 of the WBGST Act 2017 and the CGST Act 2017. System. The goods vehicle was intercepted on 26th of March 2026 at about 10:25 p.m. by the officials of Bureau of Investigation, North Bengal, Alipurdua Zone. Full stop. Alleging that the goods and conveyance were detained under section 129 within bracket 1 of the WBGST/CGST Act 2017 by issuing a detention order in form GST MOV-06 on 29th of March 2026 on the ground that the movement of goods was in contravention of section 68 within bracket 1 of the WBGST/CGST Act 2017. Full stop. The show cause notice, the petitioner was directed to show cause within a specified time frame. Full stop. The show cause notice was dated 29th of March 2026 and the petitioner was directed to give a reply within 7 days from the receipt of such notice, and he was directed to appear before the Deputy Commissioner of Revenue, State Tax, Bureau of Investigation, BOI, within bracket North Bengal, Alipurdua Zone, Alipurdua, on 3rd of April 2026. Stop. The learned advocate appearing for the petitioner submits that though the petitioner was afforded an opportunity to give reply to the show cause notice dated 29th of March 2026 and 3rd of April 2026 was fixed for appearance before the concerned authority, but the order under section 129 within bracket 3 was passed on 29th of March 2026 thereby confirming the calculation of penalty made under section 129 within bracket 1 within bracket small a of the WBGST/CGST Act 2017. First up, paragraph. Mr. Misro Lanet, yes, what is your designation?
Triple AG.
Triple AG.
Assistant Additional.
Assistant Additional Advocate General. Mr. Misro, the Lanet Assistant Additional Advocate General, does not dispute the said factual position. First up, paragraph. Section 129 within bracket 3 states that the proper officer detaining or seizing goods or conveyance, detaining or seizing ACIZING, goods or conveyance shall issue a notice specifying the tax and penalty payable and thereafter, pass an order for payment of tax and penalty under clause A, small a bracketer moddhe, or clause small b bracketer moddhe, or clause small c bracketer moddhe. Subsection 4 of section 129 states that no tax, interest or penalty shall be determined under subsection 3 bracketer moddhe without giving the person concerned an opportunity of being heard. Full stop. In the case on hand, though a notice dated 29th of March 2026 was issued, giving 7 days time to the petitioner to reply to the same, and 3rd of April 2026 was fixed for appearance before the concerned authority, but the order under section 129(3) was passed prior to the date fixed for appearance before the said authority. Full stop. Thus, the provision. Thus, it appears that the tax interest. Now, this is only with regard to penalty.
Yes, my
That
lord.
the
So only with
penalty.
regard to penalty.
That the penalty has been determined under subsection 3 of section 129 without giving any opportunity to the petitioner, without giving any opportunity of hearing to the petitioner. So, therefore, the provisions of section 129 within bracket 4 of the 2017 Act has been violated in the case on hand. For such reason, this court is inclined to interfere with the order dated 29th of March 2026, passed by the Deputy Commissioner of Revenue, State Tax, BOI, all capitals, North Bengal, bracketer moddhe, Alipurduar Zone, Alipurduar, dated 29th of March 2026, passed under section 129 within bracket 3 of the 2017 Act. So accordingly, the order dated 29th of March 2026, passed by the Respondent number
2. Respondent number 2.
passed by the second respondent is set aside and quashed. Full stop. The second respondent is giving liberty to is directed to fix a fresh date of hearing. Have you replied to the show cause?
No, my lords, we could not because it was passed on the very same day.
It could not because it was on that date.
Passed on the
How much
same day.
time? How much time is required to give reply to the show cause notice?
2 weeks, my lords, 2 weeks.
Petitioner will be at liberty to give reply to the show cause notice dated 29th of March 2026 within 14 working days from the date of receipt of a server copy of this order. First up, the second respondent is directed to fix a date of hearing and pass a reasoned order after affording an opportunity of hearing to the petitioner. First up, WPA number such and such accordingly stands disposed of with the aforesaid order and directions.
My lord, small indulgence, my lord. Similar petitioner, same.
It is however made clear that this court has not gone into the merits of the claim made by the petitioner in it is however made clear that the order of the second respondent has been interfered with only on the ground that the principles of natural justice has been violated and all points are left open to be decided by the second respondent in the light of the directions passed herein. Yes.
My lord, indulgence, my lord. The petitioner here and the goods involved in this matter also been caught by the custom authorities. The writ is also pending, my lord. That writ I have mentioned it today morning. May that writ be appearing tomorrow.
You have mentioned
That belongs to a different case because it is undervalued. It's a Myanmar quality Arekana.
My lord, that they are supposed to give the report. They have not given us the report.
Yes. Yes.
Item number 56.
56, yes.
Item 56, I am for the petitioner. I may be allowed to appear virtually. I am for the petitioner.
Yes.
I may be allowed to virtually. Am I audible?
Yes, you are audible, but you are not visible. Yes. Yes. What is this matter? Yes.
There is a suit filed by the plaintiff before the learned. So the matter is relating to an issue regarding whereupon a suit has been pending at the instance of the plaintiff against the petitioner. He is one of the defendants. Now the suit court was pleased to pass an additional injunction order against the defendant, and which is at page 67 and 68. That now the injunction order, while in operative, then summons has been issued upon the petitioner. The next date is scheduled on 30th of July 2026. Now in this juncture, the interim injunction was allowed on 2nd of May 2025. June 2026, a group of women under the leadership of a property, and they had tried for
the possession of the suit property, subject property. On there was a request between the by and between the parties and all. Immediately, the petitioner had invoked the police help. Police had come to the property, and he was made to understand what is the real factum. That even though the petitioner is pre-existing possession over the property, thereby suppressing the fact, the plaintiff has secured an interim injunction, and my representation is due to be made on 30th of July. In these circumstances, the police did not entertain any
Where is your
complaint, though I had lodged a
representation?
complaint. The
Where is your
complaint is at
representation?
page. Yes, the complaint is at page. Representation is at page, Lordship, at 110, 117.
104.
110.
110. 110, there is no representation. 110 is photograph. 106, 5 and 6 is the yes.
They are trying to civil dispute between the criminal color mirror. Their police is doing this base mirror, and all of the civil case also pending mirror. Both are party sharing their specific document before the police mirror. We have nothing to do. We are doing our best. That's the instruction that comes to the
Yes. Civil suit is pending.
Yes.
Obey with the orders of the civil code.
Yes,
Nothing.
yes. They are trying to
107, madam. Civil suit is pending. Sir, can you see? My representation is at page 107, Lordship.
Yes, when the civil suit is pending, what the police can do now?
Police can do.
Police
only
cannot do
that
anything. Please obtain orders from the civil code.
Only I am paying that I have not gone into the the issue pending adjudication because of civil suit. I am not indulging any adjudication here. Only I paying that when I am in a bona fide possession, I should not be evicted by the purported order of
the order of injunction is against you. How can you say that you are in possession?
No,
Please
no,
get
I
it
am-
vacated from the civil code.
Definitely, Lordship. I
Please
will
get it
vacate
vacated.
the next
Sir,
day-
please
next
get it
day
vacated
is-
from by the civil code, and you have also not implemented the plaintiffs
True.
in this writ
Proof,
petition.
I
Then
have not sought for any relief. I did not sought for any relief against plaintiff.
this writ
Only
petition,
I am seeking that.
sir, this writ petition is liable to be dismissed for not implementing the necessary parties.
Should I, then in that event, Lordship, I may be allowed to implead the plaintiff. I may be allowed,
Nothing.
Lordship. Lordship, I will come back
this
personally.
application-
Lordship, Lordship, may I say?
Police,
Lordship, may I say one
civil
thing?
suit is pending. I will not interfere now at this stage.
No, I'm not seeking interference.
You
Lordship.
can
Only, Lordship, I'm saying one thing. Lordship, I'm saying one thing. Lordship, Lordship, addition for this week. I am coming personally on the next week. Lordship, I will appear and I will argue on the merit, Lordship. Lordship, I will meanwhile I
this
will
application
implead
under
the
Article-
plaintiff.
No. This application under Article 226
In
of
the
the
meanwhile,
Constitution of
in the
India
meanwhile,
is at the instance of you are a defendant in the suit. Is at the instance of
Lordship was to pass a similar direction upon a
is at the instance of the defendant in is at the instance of the defendant in title suit number
98.
Yesterday was pleased to pass a similar order in a identical issue in my case. Lordship, I appeared. Lordship, I am seeking similar sort of order, Lordship, in favor of me.
Yes.
That is enough.
Yes, I will
Lordship,
be passing similar
otherwise,
orders.
Lordship, I may be
Is
allowed
at
to.
the instance of the defendant in title suit number 98 of 2026 praying for a direction upon the police authorities to take steps to ensure that the petitioner can continue with his possession in respect of the property in question till the final decision is arrived at by the civil court. First of paragraph, record reveals that Ankit Kumar Kedia filed title suit number 98 of 2026 against against Ajay Shah and others before the Lanet Civil Judge, Senior Division, Jalpaiguri Sodor Court. First up, the petitioner is the fifth defendant. Is the fifth defendant in the said suit. First up, the Lanet Civil Judge, Senior Division, Jalpaiguri Sodor Court, by an order dated 2nd of May 2026, allowed the plaintiff's prayer, allowed the prayer of the plaintiff, that is Ankit Kumar Kedia, for an interim order of injunction, and the defendants, including the petitioner, were restrained from entering into the suit land for causing disturbance to the plaintiff, that is Ankit Kumar Kedia, in his peaceful enjoyment of the suit property, and the defendants were further directed not to change the nature, character of the suit land till the next date of hearing. First up, the learned advocate appearing for the petitioner submits that the plaintiff of the said suit, accompanied by certain tribal women, came to the suit property on 7th of June 2026 for taking forcible possession of the suit property. First up, accordingly, the petitioner
CCTV camera
lodged
also
a
annexed.
complaint
CCTV
with
footage also
the
annexed.
police authorities by a letter dated June 8, 2026. First up, the learned advocate appearing for the state files a report of the Commissioner of Police Siliguri, Police Commissioner dated 1st of July 2026, which is taken on record. First up, the report states that a civil suit is pending between the parties, and a preventive proceedings under section 126 of BNSS 2023 against the concerned parties has been initiated with a view to maintaining peace and tranquility, and a strict vigil over the locality is being maintained to ensure that no breach of peace or cognizable offense takes place. First up paragraph, after going through the materials on record and upon hearing the learned advocates for the respective parties, this court finds that there is a dispute with regard to an immovable property between the private parties, dispute with regard to possession, dispute with regard to possession in respect of an immovable property between the private parties. First up, the plaintiff of title suit number 98 of 2026 has also not been impleaded as party respondents in this writ petition. First up, it is well settled that inter se private disputes interstate dispute between private parties pertaining to an immovable property cannot be decided by the police authorities. Full stop. Since the civil court is in session over the dispute between the petitioner and the plaintiff in title suit number 98 of 2026, the petitioner is left free to approach the civil court for appropriate reliefs in accordance with law. Full stop. The police authorities are the police authorities are duty bound to comply with the order and directions passed by the civil court. Full stop. The police authorities are also under a statutory obligation to maintain peace and tranquility at the locale. Full stop. WPA number such and such stands disposed of by directing the police authorities
No, only one thing.
in accordance with the directions passed by the civil court. To stop, the police authority shall also maintain peace and tranquility at the locale. The above observations, WPA number such and such stands disposed of.
And no extra legal. No extra legal discourse. No extra only one clear lordship. No extra legal attempt of disposition will be entertained, lordship. That is kindly add it. Kindly add it.
Yes, what is this? None appears for the petitioner. At the time of call, no accommodation has been sought for either. Accordingly, WPA number such as such stands disqualified for. State is represented. Just for the state.
No. Employee State Insurance Corporation.
ESI is represented. ESI Corporation is represented by its learned advocate. Yes, next. And number 58.
My lord, I beg to appear on behalf of the petition.
Okay, I am told to I'm told to.
Yes.
In this matter. Well, this is a transfer application of secondary. Kindly come to page 86 and 87. That are my transfer application. That is pending before the school authority. It's a general transfer application.
Yes.
And kindly take page 87. It was made in prescribed pro forma as well. It is pending at the school's end. School is supposed to take a decision and send it to the concerned DI of school.
Have you served the school?
Yes, delivered.
When they have received?
Received on 27th June. Delivered.
So, my
Who is
lord,
appealing for the school?
I'm praying for consideration of my application, my lord. Because the process is that first the application is to be made.
Away. তাহলে কি ও বলছিল কিছু? উল্টিটা কিন্তু পরে ছিল। মনে হচ্ছে।
বলছে আমাকে।
57, you are appearing. You have told.
Oh, my lord. I was just told that kindly adjourn it for the
57, I'm passing it over.
My lord, I'm ready.
You are ready.
Yes,
All right, after this matter, it will be taken
No,
up.
my lord. One day adjournment and Mr. Abhimanyu Banerjee is in this matter. He is on his leave before the principal bench. He will not be able to join today.
57 on the prayer of the learned advocate for the petitioner. Hearing of the petition stands adjourned for the day. Yes.
Yes, my lord, my
58,
application.
yes.
I'm praying for consideration of my application for transfer at page 86 and 87. 86 starting from 86. The process is that first it is to be decided by the school authority and forwarded to the DI, and DI will take the necessary follow-up step by sending to the higher authority. So it's a general ground transfer application. My lord, I direct the school authority to take a decision and issue NOC and forward it to the concerned DI. Because I'm eligible for transfer as per the notification date January 2022.
The petitioner is presently, the petitioner claims to be presently serving as an assistant teacher in Tarijot Junior High School. Full. The petitioner applied for general transfer before the applied for general transfer in prescribed form. First up, Mr. Lahiri Lanet, advocate appearing for the petitioner, submits that the application you have submitted the application through the school.
Yes, first it has to
You
go
have
to the
sub-
school. Yes.
Yes, they submits that the application has been submitted through the concerned school. First of, he further submits that the school authorities have not yet issued the no objection certificate in favor of the petitioner for consideration of her prayer for transfer.
Yes.
First up, paragraph. You are for the state.
Yes.
Heard the learned advocate for the state. First up, affidavit service filed in court today is taken on record. In spite of the learned advocate appearing for the petitioner submits that the school authority have been the school authority and the West Bengal Central School Service Commission has been duly served. First up, since the transfer application has been submitted and the petitioner has already approached the concerned school for no objections, comma, WPA number such and such stands disposed of with the following direction. First up, the head of the institution of Tarijot Junior High School, being the sixth respondent, is directed to consider the prayer of the petitioner and take necessary steps in accordance with law and communicate its decision to the petitioner as expeditiously as possible, but positively within a period of 3 weeks from the school, you are not for the school, within a period of 3 weeks from the receipt of a server copy of the of this order. So next, if the sixth respondent decides in favor of the petitioner, the papers along with such no objection shall be forwarded to the it shall be forwarded to the School Service Commission.
No, to the DI.
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 To the DI.
Yes, my lord, to the DI.
Shall be forwarded to the District Inspector of Schools within bracket AC, Shiliguri, immediately thereafter. First up, the District Inspector of next, the District Inspector of Schools, AC Shiliguri being the fifth respondent, shall consider the prayer of the petitioner for general transfer.
My lord, in light of the notification
And-
dated 3rd January 2022.
In the light of the relevant notification governing the field and decide such application by passing a reasoned order as expeditiously as possible, but positively within a period of 6 weeks from the date of receipt of the no objection and the relevant papers from the school authority.
Independently, without going with the.
Full stop. It is however made clear that this court has not entered into the merits of the claim made by the petitioner in the transfer application, and all points are left open to be decided by the respondent authorities in accordance with law.
My lord, if the
School
petitioner is
authority has-
executed, then the DI is supposed to send it to the School Service Commission, the next step. If the
That will be considered,
no, that is to be
according to
recorded
the
because the commission has.
school as well as the DI, both can take decision independently.
Yes, yes, I've said all
Obviously.
the respondent authorities.
Yes.
At paragraph at call, in case the district inspector of schools decides in favor of the petitioner, such decision along with the relevant materials and papers shall be forwarded to the
Respondent number 4.
shall be forwarded to the Secretary, West Bengal Central School Service Commission, being the fourth respondent, who shall take all consequential steps thereafter in accordance with law, as expeditiously as possible, but positively within a period of 4 weeks from the receipt of the papers from the District Inspector of Schools.
Grateful, much obliged, my lord.
Yes, next.
Deeply obliged.
My lord, in this matter, I beg a leave to appear virtually.
Yes, yes.
Yes, my lord, I'm appearing virtually. My lord. This matter is regarding a GST case. My lord, the prayer is very short. My lord, what happened? First, the department issued me a show cause notice, which was sent through email. After that, there was a reminder which we gave a reply to. But subsequently to that, everything went up to additional notices and order portal, which we missed out because there was a lot of mix up and jungle. And in February 2026, we first came to realize that there was an order. Well, what happened subsequently? We approached this department saying that to rectify this or give me a chance. But what happened now? What happens, my lord? As the order is passed in 2024, I am time barred to file an appeal. My lord, there is one more point.
Yes.
That there is no proper hearing was also not given. Personal hearing was not given initially. Subsequently, after a reply, there was no reply. My lord, my humble prayer is that let it be sent back so that it can be heard again.
Yes, Mr. Mishra.
For space 27 for a moment.
27.
2727. He gave a reply to the show cause notice. That is there as space 27. In column 7 thereof, there is an option that has been asked from him whether he want to attend a personal hearing or not.
No, they said no.
So now
My
what?
lord, this is where I want to place one thing, my lord. This option comes automatically. There was a system error. My lord, even if I give no, the law says that they have to give me a personal hearing. That is 75(4) says it. Whether I ask for it or not, they have to give me a personal
Because he has
hearing.
uploaded 2 documents here. One is reply.pdf, one is ma.monusha.pdf, and then when it comes to personal hearing, he says no.
My lord, even for that.
So where is the adjudication wrong?
My lord,
In column
my lord,
6,
let
the
me place
documents have been uploaded.
75(4).
In column 5, reply is also there.
Where is the final order?
My lord, the final order is the next.
29 and 33.
29 and 33 minutes.
29 is
29 is the summary,
and 33.
33 is the detailed order. Yes. This is a case of a mismatch.
My lord, the second problem that comes that this order was uploaded in the additional portal. My lord, as I can place before your lordship, there was a judgment of this division bench where it says that additional portal service of additional portal is a bad service. No, my lord, it was
Yes,
margin.
sir. So what do you say to this? If it was in the additional portal, he has lost out on the time to prefer an appeal. Additional notice and other things that portal.
There is a usual order that gets passed in all those cases wherein.
I think I have also passed an order. Are you carrying that order?
My lord, I have a order of the principal bench.
I have delivered one order on that. Relying on the division bench decision.
I am caring for my case and big one. My case is also.
But in this
So
case,
your
my lord,
case is also that.
if I can have my lordship for a moment on page 35, it is their own document. They are giving here the screenshot of the portal. Page 35, my lord.
Page 35.
Dashboard from drop down they have come to services. From services drop down they have come to user services. From user services drop down they have come to view notices and orders. Additional
This
is not
is
there.
after February. My lord, see the date, site last updated on the page 37. This is the present situation of the portal. It was not there in 2024. My lord, I've clearly submitted that the portal got merged in February 2026.
Yes, now it has been merged.
Yes,
now it has been merged at
February.
relevant points of time.
Maybe it was not there.
Have you seen this order? Or you want to go through this? Then I can.
We can do, kindly give me a password notes. We will just go through it once.
All right. Please give him a copy.
I understand there are usual orders that are getting passed because of this additional tab.
Yes, yes.
It happens all the time.
Also, my lord, last week, my lord, our Honorable Justice Kaushik Chandra and Honorable Justice Smita Das passed the order clarifying that the additional notices and portal that 5th February 2026 are both March. In my case, I attached my screenshot. I will show, my lord. Let us develop.
My lord, I have submitted that. My lord, my
without-
junior has a
without-
attachment
They
of
have-
justice there.
Additional both
That is
March,
March. There is no
without
relevance.
any notification circular from 5th February. And we got knowledge from the media news. We are also carrying that. And I am carrying this Honorable Justice Kaushik Chandra order, also Smita Das, the Justice
My lord, my
Smita Das. the order.
junior has the Smita Das their order. S. Batra.
Last Thursday passed, last Thursday.
Yes, my learned junior is having this judgment, Sunil Batra judgment.
এই কোন order?
This is passed.
কি নামটা? হ্যাঁ, সুনীল বাত্রা। This is Justice Chandra, sir. এটা দিন।
Yes.
This is Justice Chandra.
কৌশিক চন্দ্র। All this clarification. Honorable Justice Chandra's order more clarified.
Yes, here it has been only.
Oh, Mr. Misra.
But then the question would still remain because he has already opted for no personal hearing. Then how would everything else be applicable in his case?
My lord, 75 force says that even I opt for it, they have to give it. It's a compulsion on them to give me a personal hearing.
Because here, Mr. Misro, you have said that in this notice,
Yes.
date of personal hearing has been fixed. Time of personal hearing has also been fixed.
Yes, my lord. They
So-
reply to it. The reply is at page 27.
Yes, so
Because this is not a case wherein NA has been given. This is the
no,
case
no,
where
no, that is, yes.
yes, this is the case wherein they are replying to it.
Yes.
In their reply, in column 5, they say, I
But
have
yes,
included
what
the
do you
personal-
say that you have said you don't want to You don't want a personal hearing.
And the documents have been uploaded.
Well,
Maybe
the
the
problem
statute
is
says,
with the
but if you
system.
say that you don't,
Well,
if
even
you
then
say
they
that
have
I
to
don't,
give it.
I cannot arrest somebody and bring for a personal hearing.
how?
Well,
If you say I
I'll
don't want a
place-
personal hearing, how they will bring you?
My lord, I'll place this case.
How
My
they
lord,
will
what
bring
happened
you?
ini- My lord, that is what I'm trying to place, my lord. What happened initially in the portal, whatever you applied for, it became no. My lord, I can give you number of cases where
Yes,
then
sir.
automatically became no. Subsequently, the portal got
Automatically
rectified
become
and
no.
Can't be true.
That cannot be.
there are- My lord, I
That cannot
can
be.
place-
Where have you stated that automatically it has become no? Have you stated on oath? Then I have to give them an opportunity to file an affidavit with regard to that.
Yes.
That cannot
my
be.
submission is my submission is not on 75.4. My submission is that the order was uploaded in additional portal. I lost the
No,
opportunity
that's,
to file an appeal.
That is
My lord,
inconsequential.
Only one thing, to file an appeal, that is one thing that can be tested in 226.
Yes.
But not on the ground of failure of
Natural
natural
justice.
justice.
Yes.
No, my
On
lord,
merits,
I'm
you can
not
argue.
pressing in this manner. Not on, my lord, I'm not pressing this matter on 75.4 or not giving hearing notice. My lord, we have replied. All I'm asking for a time to file an appeal because that has gone. My lord, if the lordship allows me 4 weeks or 2 weeks, I will file an appeal. I want to use my alternative remedy, which I have lost because it was uploaded in additional notice portal. That's all my prayer is. In
Yes,
this.
Mr. Viso, what do you say to that? He says only because he has the right of appeal. He says since
So the adjudicating authority order stands as it is. He is only asking
because
for
he does not
Yes,
want
my
for
lord, that
setting
is my
aside.
prayer.
That's one thing. He wants to go before the
File an
appellate
appeal.
authority.
So can you come back with instructions? I'm keeping it
We'll do that.
tomorrow.
We'll do that.
So yes, so that's clear. You are not challenging
Yes,
the
my
order
lord,
of the
my
adjudicating
only
authority.
prayer. No, my lord. I'm challenging on the fact that I was not served properly. Let me file an appeal. They will not reject me on
All right.
count of delay.
We let the appeal, we will allow him to file appeal. If the adjudicating authority is not being
Take
challenged,
instructions, then
we will do
that submission.
We'll do that.
Ashwin, the learned advocate appealing for the petitioner submits that please take it back. It may be in another case because here they are not going by this.
But then here another thing, he has never tried to file an appeal. Generally, what happens is a person approaches the appellate authority by filing APL 01 and then there is a rejection because it is barred by limitation or whatever.
But
He hasn't even
says,
tried.
No, he has not filed because he says now the appeal is time barred. If you take
No, but
instructions, he will no. If you take instructions that he will allow him, I will fix a time limit within which he has to prefer an appeal. Because he says by the time.
No, because that delay is, I mean, on the part of the authority, we cannot condone the delay until unless the court order is there.
So because on this, please consider that because I will permit them to file an appeal within a certain time. 2 weeks or 3 weeks within that time. Because on this, since this was uploaded in the additional notice and orders, he could not. It cannot be said that this order was duly served upon him. So he came to know from that. He has approached. I will relegate him to the appellate forum. Please take instructions on that. I am keeping it tomorrow. The learned advocate appealing for the petitioner submits that since the order was uploaded in the additional notice orders tab and not in the general notice and orders tab, the petitioner was not aware of the order passed by the adjudicating authority. First off, he submits that for such reason, the petitioner could not approach the appellate authority. First up, the learned advocate appealing for the petitioner prays that the petitioner is ready and willing to avail the appellate authority, appellate remedy if the court permits the petitioner to avail of such remedy at this point of time. First up, the learned assistant additional advocate general prays for an accommodation, to revert back with necessary instructions.
Well, it can be kept on Thursday,
Yes.
my lord. This matter can be kept
Tomorrow?
on Thursday. Malad, Thursday because I already have a matter.
All right, Thursday. This matter on Thursday. Yes, next.
Malad, in the same, this is the matter where the show cause notice hearing was not given. And also, Malad, subsequently the order said that there was a scrutiny of return under section 61 where
next matter,
ASM
next
detail was
matter.
not given. Yes, Malad, the next matter.
Call the next matter.
Sorry.
Item number 60.
Malad, I'm for the petitioner. Here,
Yes, Mr. Vishnu, you are appearing.
yes, Malad. Malad, page number 26.
কোন ফাইল দিলে কোন ফাইল দিলে 61 দিয়েছেন 60
26 দেখতে গিয়ে बात करना पड़ेगा अथॉरिटी से किस में से आ रहा है सब
Yes.
I
What
want to
is
play
this?
Number 26. Malad, with the same issue, Malad. Here, hearing was not given at all. Malad, page 26.
Oh, here there is NA.
Yes.
Yes, ma'am.
Malad, even
Yes.
subsequently, if I, Malad, kindly Lordship comes to page 30. That's the order. Malad, page number 30, Malad.
Yes.
Malad, this order talks about, Malad, in the first line, they said that you have been scrutinized under section 61, read with rule 99. Malad, rule 99 contemplates of a ASMT 10, that is scrutiny of return. Malad, this ASMT 10 was never issued to us. They directly started with show cause notice, which is not permitted as per law. If they are telling that there is a scrutiny of return under section 61, rule 99, Malad, if I can place rule 99, it talks about ASMT 10 that has to be issued. Malad, page number 30, the entire order starts on there.
तो वही वाला जवाब देता है हर जगह
Yes.
Malad, this ASMT 10, Malad, rule 99.
That's 07. That's 07.
Did your Lordship got it? Malad, rule 99. One.
Rule
99, Malad. That corresponds to the section 61. This is the rule. Rule 99.
169.
Yes.
Malad, this
Yes, rule 99.
contemplates of a ASMT 10. They said that if there is a scrutiny of return, the department first has to issue me a ASMT 10. I will reply in ASMT 11, then they will pass an order accepting or rejecting in ASMT 12. Then they can proceed with show cause notice. They completely eroded this step. They directly issued me a show cause notice saying that I have scrutinized your return.
169 1, 169 2. 169 1, 169 2.
Yes. Yes, Mr.
But this is one point that they have to issue me a ASMT 10.
This will be fair.
169. Lordship announced there is a judgment on a similar fact passed by the coordinate bench in matter of MX services and another.
Yes.
My learned junior friend will hand over the judgment, MX services and another. Well, this it's the same thing that has happened in this fact where the entire proceedings was set aside and a fresh adjudication starting from ASM T10 was contemplated by the Lordship. Same problem happened that ASM
Yes, sir, Mr. What do you say? What do you say?
Not sir. What is there on record is on record, notes cannot be improved upon. Page 26, NA is there.
Yes.
Now, let's whether an order in terms of this particular order can be passed or not, in this case also we will come tomorrow.
Tomorrow? All
Day
right.
after, my lord. My lord, it
A
can
day
be
after
taken
tomorrow.
Day after tomorrow.
Art the learned advocate for the petitioner on the prayer of Mr. Learned Assistant Additional Advocate. This matter day after tomorrow. Yes, next.
Item number 61.
Yes.
My lord, 61 and 62, both are same. Yes, I am.
Yes.
Your Lordship, similar order as item number 14, Your Lordship.
Item number 14.
Yes, Your Lordship.
Same as item number 14. Yes. Disposed of. Next. 62. 62, you are appearing. Same.
62 is also same, Your Same.
Same as
Then
item number 14.
80.
Disposed of.
Your Lordship, there are other matters.
Yes.
Do I give the case numbers?
Yes, who is appearing for the petitioner?
Your Lordship may call it serially.
Yes, yes. Correct, Naku?
62. 63.
The service is not yet completed, Lordship.
One day accommodation.
What is
Lordship.
this matter?
Lordship, the petitioner is the widow of late Nagendranath Sinha. He was employed staff of Irrigation and Waterways Directorate Government of West Bengal. After his retirement, Lordship, he died on 20th August
You
2000.
have applied for pension on in 2018.
Yes, Lordship.
Irrigation and Waterway State. Who is appearing?
Lordship, service is not yet completed.
Service.
Only one day
Yes.
accommodation, Lordship.
Yes, can you appear for the state?
Which matter, my lord?
Pension, he has filed an application. Please take a decision on that within the time.
Yes, sir.
Ashwin, please serve a copy.
Yes, Lordship.
You have given your copy.
Lordship, but by today, during the course of the day, I'll give it. Lordship.
Your regularization is to be done.
Yes, Lord.
Regularization is to be done. Appointment regularization.
I have to take my AGP. I have to take. Pune Jeta will appointment. It will not be a wish.
So AGP, so no, so you can appear. Ashwin. The petitioner. States that her husband what do you want? Pension?
Yes, Lordship.
Contractual employee, how can a pension be granted?
Lordship,
Contractual employee, how pension?
Lordship, kindly come to Annexure P8, Lordship.
P8.
Yes, Lordship.
Page
Lordship, P8, page 23, Lordship.
23.
Yes, Lordship.
Yes, you have submitted.
Yes,
How are
Lordship.
you entitled to pension?
Lordship, then come to Lordship, Annexure P6, Lordship, which is in page 20, Lordship.
That's the pending criminal case. You are a contractual employee. contractual employees entitled to pension.
Lordship, please, Lordship, kindly give me 1 day accommodation, Lordship.
What 1 day
This petitioner
accommodation?
is entitled to get pension, Lordship. Give me 1 day.
Contractual employee. Please show me the rule. I think that will benefit others. Please show me a rule that a contractual employee is entitled to pension.
Lordship, kindly come to Lordship, Annex to P9, Lordship.
Yes. Yes, P9.
Yes, Lordship. He was not a contractual employee, Lordship. He was made permanent on 5th of March, April, May, June, 5th June 1992. His post was declared permanent, Lordship. Then he took his superannuation and then he died on 20th August 2018. But before his superannuation, he got permanent, Lordship.
Where have you stated that you have become permanent?
Lordship, kindly.
Kindly make it 1 day, my lord.
Lordship, kindly come to Annex to P5, Lordship. He was not contractual, Lordship, when he took superannuation, Lordship.
All right, give him a copy.
Kindly make it Monday, my lord.
Monday.
No, Lordship, tomorrow, Lordship. Just, Lordship.
I have
just
to take
during the course
instruction,
of
my lord. I
the
have to
day.
take instructions.
A copy of the learned advocate appearing for the petitioner submits that she shall serve a copy of the writ petition upon the learned additional government pleader in course of this day. Fuster, the learned additional government pleader seeks time to revert back with necessary instructions to establish this matter on Monday. Yes,
Yes,
next.
Lordship.
Please serve him a copy.
Yes, Lordship.
Yes.
Item number 64. Lordship, I am for the petitioner, Lordships. In this matter, this is tender matter, Lordships. Work order in favor of me, but after the passing work order, as per my verbal instruction, after 2 years, the work order execution authority cancel the work order. After complete the work, complete the work order. Okay. Lordship, this matter
Completion of work orders cancelled.
Yes. Work order issued in the year 2024.
Yes.
60 days limitation. I will complete the work and paying for
Work completed.
Yes, work completed. But
Then how can
completion-
the work order be cancelled thereafter?
I don't know, Lordships. I don't know. After 2 years, they are issued the work cancellation, work order cancellation.
What is your prayer?
My prayer is to release the my admitted team. But this matter, I think, Lordship, this matter can't be heard without exchange of affidavit, Lordships. These are lots of facts here.
Have you served? You are
Yes, yes,
appearing.
I am appearing, my lord, the petitioner before lordship continuously give a false information by way of affidavit, my lord. But the proceeding will not be initiated against the petitioner, my lord. That should be taken into consideration.
File your affidavits.
Yes, yes.
After hearing the learned advocates for the respective
Lordship, this is
parties and considering the nature of the relief claim, this court feels that the petition can be decided only after exchange of affidavits. First of, there is no scope to pass any interim order at this stage. First of, let affidavit in opposition be filed within 4 weeks. Affidavit in opposition be filed by the respondents within 4 weeks from date. Reply thereto, if any, be filed within 2 weeks thereafter. Parties will be at liberty to mention this matter for inclusion in the list under the heading hearing after expiry of the period fixed for exchange of affidavits.
Lordship, let petition be admitted. Let petition be admitted. Let petition be admitted.
Read petition.
Let petition be admitted. Petition be admitted. Okay, thank you, sir.
Yes. Item 65. Yes.
Yes, Lordship. I on web the petitioner, Lordship.
Yes.
Lordship, the petitioner is the assistant school teacher, Lordship. He joined in the school 20th July 2001, Lordship. Page number 16, Lordship.
Page
16. The
Yes.
recommendation letter, Lordship.
Yes.
And he joined on 20th July 2001, Lordship. Thereafter, Lordship,
What do you want now?
Lordship, I want two additional increments, Lordship. Thereafter, he got the PhD degree, Lordship. Upon prior permission getting the managing committee, Lordship. Page number, Lordship, 20, Lordship.
As scale of pay?
Yes, Lordship, not low. Yes, Lordship, and two additional increments, Lordship. He is the PhD degree holder, Lordship.
Yes.
And I made a representation, Lordship.
Page 20.
That is not considered by the authority, Lordship. Page number 24, Lordship.
In case number 24, Lordship, he has presented a representation before the district inspector of the school, Lordship. But Lordship, by the memo dated 17th September 23, Secretary Education Department Law clarified that hence all the district inspector of the schools are instructed not to rely on GO number so and so dated 5th January 2012 by disposing of incremental benefits of the teacher acquiring the PhD degree. The case may be referred to the Commissioner of the School Education for advice. In this case, on 25th June 2026, the DI has wrote a letter to the Commissioner, and that is still now pending because only
So let them, my
20
representation be considered, Lordship.
20 days ago he has wrote a letter.
So I can direct the commissioner
Yes,
to
Commissioner.
consider this case.
Yes, Lordship.
So, have you made any representation to the, yes, Commissioner of School Education also, he has made a copy.
Yes,
So I'm directing the commissioner to take a decision.
Lordship, this is the affidavit of service, Lordship.
The petitioner is presently serving as an assistant teacher in a high school.
Yes, Lordship.
In a high school.
Purvanchal High School.
In a high
HS,
school.
Higher Secondary. Jalpaiguri, Lordship.
In the district of Jalpaiguri. Full stop. The petitioner states that he has undergone the PhD course after obtaining prior permission from the managing committee of the school. First of the petitioner states that upon successful completion of the said course, the petitioner was awarded PhD, P capital A small full stop D, in Bengali in the convocation ceremony of the university by the Honorable Governor of the state of West Bengal on 5th of May 2009. First of the petitioner states that upon being awarded the PhD degree, the petitioner is entitled to two TWO, special increments, TO, two special increments as per the extant rules. First up, the petitioner submitted a representation dated 26th of May 2026 before various authorities, including the District Inspector of Schools, Secondary Education, Jalpaiguri, and the Commissioner of School Education, Department of West Bengal, School Education Department, West Bengal, by letter dated 26th of May 2026. First of the learned advocate appearing for the petitioner submits that in spite of receipt of such representation, no decision on such representation has been communicated to the petitioner till date. First up, Ms. Singh, what is your designation?
Junior government pleader. Junior government pleader.
Junior government pleader. Ms. Singh, learned junior government pleader, submits that pursuant to a departmental memo, the District Inspector of Schools has referred the matter to the Commissioner of School Education. First of, she submits that presently the issue is pending consideration before the Commissioner of School Education. First of paragraph, in the light of the submissions made by the learned advocates for the respective parties, WPA number such and such stands disposed of by directing the Commissioner of School Education, being the
Respondent number 2.
second respondent, to consider the representation of the petitioner dated 26th of May 2026 and dispose of the same by passing a reasoned order after affording an opportunity of hearing to the petitioner or his authorized representative, and communicate the reasoned order to the petitioner immediately thereafter. Full stop. The entire exercise shall be completed by the second respondent as expeditiously as possible, but positively within a period of 4 weeks from the receipt of a server copy of this order, together with a copy of the representation dated 26th of May 2026. Full stop. It is, however, made clear that this court has not gone into the merits of the claim of the petitioner made in the said representation, and all points are left open to be decided by the Commissioner of School Education while passing the recent order. Full stop. It will be open to the petitioner to place reliance upon any government orders, circulars, orders of the court in support of his contention, and if such documents and orders are placed before the authority, the second respondent shall consider the same and pass orders accordingly. Yes, next.
There 66.
Lordship, writer number 66. Lordship, for this matter, I have a very innocuous fear, Your Lordship. This is a GST matter under section 129. Lordship, I was detained on the 22nd of October 2024. Thereafter, on the 28th of October, show cause notice was passed. An order with an order under DRC 07 was also passed. And Your Lordship, subsequently, I tried to file my appeal. I first filed a representation. Then I filed my appeal on the 24th of January within the limitation period.
Within the period of
Yes, Your
limitation.
Lordship, but they did not provide me any provisional acknowledgement. After that, I filed, I have, submitted a further representation for them to consider my situation, but they did not.
So what is your instruction?
Lordship,
Because they have filed an appeal, they say that within the time.
Lords, I see in page number 50, there is a.
Consequently, after filing my representation and after the filing of the writ petition, they have given me the GST ID portal through which I can electronically file the appeal. But after that, subsequently, I have filed the appeal as well, but I did not get the acknowledgement as of now as well. So that is the only situation that.
Yes, Mr. Mr. Can you come back with instructions?
We will have to do that because in page 50, she's showing a GST APL 01. Now, this is whether this is portal generated or
This
not. There
was
is
the
something.
manual appeal that we had sent through registered post, Your Lordship. After
But
that,
there is no provision of filing manual appeal in the
Lordship,
GST.
under Rule 108 of the CGST Act, when we do not have the
Please
electronic.
take instructions.
We will do that. We will do that.
When?
Monday, my lords.
Monday. On the prayer of the learned advocate for the state list is better next.
Affidavit of service.
You receive.
Yes, next.
Item 67. Lordship, I'm praying for next cycle because my client is out of station. I have a little bit instruction, Lordship.
What instructions? You have filed the writ petition. What instructions?
No. Little bit instruction, Lordship. I need a little bit instruction, Lordship.
What instruction?
The reason order is, I am challenging the actual reason order. The reason order is not clear to me. Lots of things here.
Where is the reason order?
Page 32. Answer responding is NBCC, Lordships. And NBCC is not here also. I have already served.
NBT.
Respondent number 4 and 5 is the answering respondent, Lordships.
They're not here, right?
What was your prayer before the authority?
To set aside the reason order, actually my salary is sometime they are giving more salary, sometimes it's low salary. Actually, I'm challenging page number 32, reason order.
30?
32, page 32.
What was your prayer before the authority?
Lordship, back to increasing my salary. Before after last 2 years ago, my salary was 14,000, and after that they have decreased my salary in 13,500. It's page number 22. This is
Where is your appointment order? Order of appointment?
page 21. No, Lordship, page 17. Lordship. Stand corrected.
17.
17. 17.
Yes. So now what is the amount which you are getting?
11,000 something, Lordship. They have to take instruction, Lordship.
Petitioner has challenged a reasoned order of the, has challenged an order, challenged an order of the managing director in BHTC dated 9th of April 2026. So stop. There is no scope to pass any interim order. So stop. Let affidavit in opposition be filed within 4 weeks from date. Reply thereto, if any, be filed within 2 weeks thereafter. Parties will be at liberty to mention this matter for inclusion in the list under the heading hearing after expiry of the period fixed for exchange of affidavit. Yes, next.
68.
68, Your Lordship, I'm praying for not this week, Your
Why?
Lordship. I'm late by Dr. Naveen Parikh due to personal difficulties. He is
You are late by?
Dr. Naveen Parikh, Your Lordship.
You are here. You are moving matters. Yes, what is this matter?
And no, Your Lordship, kindly fix this matter. I didn't even bring the brief today. I missed it, Your Lordship. Kindly fix this matter next week, Your Lordship. If he wouldn't be available, I would proceed with the matter, Your Lordship. Kindly fix this matter. Your Lordship, kindly fix this matter next week, Your Lordship.
On the prayer of the learned advocate for the petitioner, list this matter next Monday. Next Monday. Next.
Grateful, Your Lordship.
Item number 69.
Actually, these are all SR matters. And here we'll hand over the affidavit to service.
Yes.
Madam, we are appearing, madam. Miss Anamika Pandey, madam.
Yes. Same order.
Agent.
Disposed of within election commission.
Yes, affidavit to service. This is the order passed by Justice Krishna. Lordship has already in the
They
morning.
have passed an order. Same as item number 14.
Yes.
14. This is the affidavit to service taken.
Same as item number 14.
Affidavit service.
Every service taken on record. Yes, disposed of. Next. Next.
List.
Item number 70.
Same. Same order. Next.
71.
Same order. Next.
72.
Same order.
73.
Same order.
74.
Same order.
75.
Same order.
76.
Same order.
77.
Same order.
78.
Please, my lord.
Yes.
I am appearing for the petition, my lords.
My lord, in item number 78, just today morning, I have received the
brief. Kindly allow me 2 days accommodation for my preparation. My lord. He can, just today morning I have been interested. Kindly.
My lords, one more point. My lords, the goods that they have seized on the reason to believe that it's a foil.
When it was served upon your client, you may have been
Yes,
given
yeah,
today. That's
practically-
not their headache.
No, practically, but today morning.
It was served on 6th July, my lord.
6th
It
July,
can
it
be
was served.
6 July to the Calcutta.
Yes.
It is the office
How
of,
much time it takes?
practically from Calcutta to Alipurduar, then it was entrusted to me. Kindly give me 2 days accommodation for my preparation, my lord.
That case, my lord, there is a affidavit.
Yes, that's true. That I am not denying, but for my
What
preparation. my
is
lord.
this matter? What is this matter?
My lord, this is a matter. My lord, this is a
Yes.
matter wherein I am challenging the Caesar memo, on which, my lords, my icon was seized on the grounds that it was of foreign origin. Subsequent to the seizure, they conducted a verification. They sent it to ARDF lab, and it was found of Indian origin. Till date, my lords, they have not released my goods.
All right,
Have been
Mr.
found.
Bonik, when tomorrow?
Day after tomorrow. One more day. Day after
All
tomorrow.
right, day after tomorrow.
Get
Tomorrow, my lord, because the report is there and they had.
Yes, I have to.
Day after tomorrow, you will be here.
Tomorrow
Ashwin.
I am here, day after.
My lord,
You will not
even
be
the
here.
show cause notice states that it's of
You
Indian.
are coming.
Hearing
You are
would be
coming
met
from
by his-
Calcutta.
by her senior. Hearing would be met by her senior through online. Day after tomorrow, surely I will come.
She will be leaving Calcutta. She is here tomorrow. On the pair of Mr. Bonik, learned advocate, appearing for the. This is customs.
Customs.
Customs authority lists this matter tomorrow. Yes, next.
Item 79.
Well, I am for the petitioner. That's what I am. Yes.
My lord, it's AGP, senior counsel AGP will be appearing. He is in court number 8, so not today.
Yes. What is this matter?
My lord, petitioner before your lordship, my lord, kindly see, my lord, prayed for, my lord, approval of his appointment. My lord, petitioner came before this honorable court on earlier occasion. My lord, kindly peruse the order of the earlier, my lord, order. My lord, page 27.
27.
My lord.
Yes.
My lord, it was directed by this honorable court to consider the representation of the petitioner and to dispose of the same.
Yes, then what happened?
The authority, my lord, considered my prayer and passed a reason order, but which is at page, kindly see, the relevant part of the impugned order, page 44. Observations.
Yes.
My lord, I am skipping over the first two paragraphs. Hence, my lord, kindly peruse this. Hence, the undersigned not being the competent authority as per para such and such, read with such and such of Secretary, Department of Panchayat and Rural Development to approve benefit to the petitioner, sending all the relevant documents along with observations made above for according necessary approval to the Additional Chief Secretary, Department of Panchayat and Rural Development. All the papers and documents is lying with the Additional Chief Secretary, Department of Panchayat. But I am praying, let there be a direction upon this secretary to take decision in the observation which has been made in the
Yes.
prison
Where is
order.
the
Learned AGP is in hearing, doing hearing in court number 8, so not
Ask
today.
him to come. I'm passing it over.
Well,
Ask him to come. Yes. 415. Yes. 80. Yes. 80. Election Commission.
Your
Same order.
lordship, similar order.
Yes. Next. 31.
I'm for the same.
Who is for the petitioner? What is this matter?
It's a grant of fair price swap license, Lordship. They say that the private respondent who is awarded the license, Lordship, that is unfair.
January 2026.
Cancel the license of respondent number 6.
That's the pair.
Yes. Prayer A. Page 11, Lordship. Petitioner is one of the
Petition
candidates.
affirmed on January, filed in July.
It's January. January. It's not January, Lordship. January.
It appears from the writ petition that the writ petition was affirmed on 9th of January 2026. Yes, yes. Affirmed on January, filed on July. Why? Why this long delay? Yes, yes.
Not one document was.
Forum shopping.
No,
Then
first time filed, madam. Or I see no
that is
other
what I am
thing.
asking.
No,
From January to July, why?
Waiting for
How many circuit benches in the meantime?
The weather was not good.
Yes.
Now because there is a favorable weather.
Yes, yes. What is this matter?
No, I have served, madam. Private respondent not.
Private respondent?
Not yet received.
Not received.
Not delivered, madam.
Not delivered. Yes, what
Madam.
is this matter?
Yes, madam.
Yes. When have you sent? What is the date of?
Madam.
10 number 10. This is for license cancel करने के लिए बोला है. लेकिन उसका guarantee.
15th of July, madam.
January 2026, petition affirmed. Court fees paid in January 2026. Petition filed on 1st of July 2026 with the date mentioned on 20th of July. Copy forwarded on 15th of July. Yes, now you can proceed.
Madam.
Yes. Yes, what is this?
Madam. Madam, page 14, annexure P1 is the application, madam.
Page 14.
14, annexure P1 is the advertisement. For
Yes, what are you challenging?
Madam, I am challenging, madam, the private respondent given the fair price shop. This is the advertisement for fair price shop. 3 person, my lord, he appeared in the proceeding, my lord.
You also appeared.
I also appeared, my lord. I also appeared, my lord. Kindly they given mark, my lord. I have the all qualification. If my lord, there is a two process according to advertisement. And if I qualified, then they will call for physical. They will came for physical verification. If I allowed for qualified for physical verification, then they will call for the viva. And thereafter only there is a marks. They given only 0. 2 person given 0 and 3 person already given. I also given my lord RTI
Yes.
My lord.
Yes.
Out of my 75, I given 0 during physical verification. And private respondent, my lord, given 62. And another person also given 0. My lord. There are 3 persons, my lord.
But here, which page is the mark sheet?
इससे क्या होता है ना मुझे नहीं पता। अच्छा नहीं पता।
My lord, annexure P7, my lord, page 32, my lord.
Yes. Page 32, there is only 2 persons.
Yes, my lord. And 2 persons, my lord. There are 2 persons, my lord, given my lord RTI, my lord. I present petitioner, my lord. Can you see my lord present petitioner is
Lordship, can you see the remarks, Lordship? See the remarks.
Yes, my lord.
Why 0 has given, Lordship?
Yes, my lord. Kindly see the notification also, my lord. Notification says that if I qualified, my lord, come to the notification first. My lord.
Show me.
My lord. My lord, page 15, my lord.
Yes. Yes.
Page
Page 15.
15, my lord, page 15 notification, my lord, clause 5.
Is not readable, Lordship.
Yes, 15, my lord, clause 5, my lord.
Page 15, clause 5. Yes.
Yes, my lord. There are 3 conditions, my lord. If the structure, my lord, my lord, if the structure of the floor and wall proposed go down is complete, 4 is otherwise ready, out of this, my lord, not done, then, my lord, it's not done, overhead absence of structure, my lord. And next, my lord, on process of the application, in case of incomplete go down if the applicant is otherwise found to be eligible and criteria for engagement of FS dealership are fulfilled, then license will be issued after the inquiry and uploading photo regarding completion of the license and etc. as the case may be. However, if the wall, floor or incomplete of the day of the inspection, then go down will be treated as incomplete and application will not be further proceed. If physical verification, the go down will be incomplete, then application will not be further proceed, my lord. This is the clause 3. And after inspection, they call for letter for viva. I went to the viva.
So this is the marks after viva.
Yes, my lord.
Yes.
Viva they given marks and physical verification they did not given any marks. Kindly came to my lord page 29, annexure P4, my lord.
Page 29.
Yes, my lord, annexure P4. Page 29 is the annexure P4. They call for physical verification. They came to the physical verification.
Yes.
Thereafter, I went to
Upon
the
physical verification, they found that the boundary height of the boundary wall is not up to the.
my lord. If the physical verification they found if any inconsistency, then I will not call for viva. Page 30, they call for viva. Page 30, next page. This is the my lord, condition laid down in the proposed advertisement, my lord. Clause C. And 2 person, my lord, given 0. Clause page 30, they call for viva. Advertisement says that if it is, my lord, incomplete, then application will not be further proceed. How I call for viva, my lord? And there is a criteria. I annex the guideline. This is a score. How, my lord, score will be provided.
Where is that for viva that when it will be called? Where is that in the notification?
My lord, on page 30, I call for viva, my lord.
Please show me that according to you, unless you succeed in that physical inspection.
Clause C, my lord. If any of the wall or floor or ceiling, my lord, page 50 is the advertisement.
No, where is where it has been mentioned about this viva? Please show me that.
My lord, kindly see the page 15, my lord. Page
Yes.
15, clause C says the if wall, floor, ceiling.
No, that I have followed, but it does not
If-
say with
Malak,
regard
if-
to the viva. Please show me the condition with regard to the viva.
This says that there is a 2 condition, my lord. If says that if it is incomplete during physical verification, the application will not be further proceed.
No, where does it say that you will not be called for viva? Please show me that. According to you, if on physical verification it is incomplete, you will not be even called for viva. Where is that in the notification?
Then the term says that the application will not be further proceed.
That's after viva, it has been not proceeded with.
No,
You cannot show.
Just a multiple stage of
Mala
procedure.
kindly
Lord.
see, Mala kindly see the
One by one,
advertisement.
they have completed the
Mala page
procedure. Lord.
33. Mala come to
They
Mala
found
page
that the
33.
33.
33. And page 33, 34. This is the guideline. How marks will be distributed, my lord. The physical verification, they given 0. 33 and 34. No, 34 and 33. 33, 34, my lord. Regarding size of the godown, whether is a widow,
Yes.
scheduled caste, all the category, my lord, they are given marks, and thereafter, my lord, 70
minimum
marks they will
requirement is-
distribute, my lord.
Lordship, the minimum requirement was 8 feet. And the proposed go down, which the petitioner has, Lordship, 6.42 feet, Lordship.
Yes.
That's why he has given 0, Lordship.
Mala kindly see.
And merely just calling upon the viva is not created any
If
distinct
any
right to the
person
petitioner that he is
unsuccessful,
entitled for the go
If
down,
any
Lordship.
person unsuccessful preliminary stage,
But
they
only
will call for
one thing,
Yes, Lordship, because
how can it be 0?
Yes, ma'am.
Because this gradation of these marks cannot be 0.
the criteria itself says that the requirement is 8 feet, Lordship. Is
Yes, on that count, he can get 0,
yes, Lordship.
but not total. 75 is distributed among so many categories. How can it be total 0? Because you see, this 75 is the total marks.
Yes, Lordship.
According to the status, it has been stated, this is the marks. Then category, then some marks. So he must be getting some with possession, ownership, some marks. Resident of that locality, that is also some marks. Total is 75.
Lordship, then direct for filing opposition, Lordship, because without opposition, we cannot actual dispute, Lordship.
Mr. After hearing the learned advocates for the respective parties and
The department has
considering
given zero to the-
the reliefs claim in this writ petition, this court feels that this writ petition can be decided only after exchange of affidavits, let affidavit in opposition be filed by the respondents within 4 weeks from date, reply thereto if any, be filed within 2 weeks thereafter. Parties will be at liberty to mention this matter for enlistment under the heading hearing after the expiry of the period fixed for exchange of affidavits. Considering the fact that the private respondent has already been selected and is running the fair price shop this court is not inclined to pass any interim order at this stage. Yes, next. 82 Election Commission. Yes, same order as in 14.
Your Lordship.
Yes, next.
May it please your
Yes, my
lordship,
lord.
I'm appearing for the petitioner.
I'm from respondent number 4, private respondent.
This matter relates to construction of a RCC frame structure without any sanction building plan within the jurisdiction of Siliguri Municipal Corporation. May I take your lordship?
Yes, Siliguri is here. Yes.
May I take your lordship to page 38, my lord? The petitioner made a representation alleging that the private respondent number 4 has constructed a RCC frame structure in and over a.
Without taking any sanction plan.
Without
Yes, you
any
are the private respondent.
Yes, for number 4.
Yes,
My
municipality.
humble
what is the
submission,
instruction?
my humble submission, my lord, is
This is a representation. Yes. Representation is dated as 17th June, and on 1st July they have filed that.
But illegal construction, my lord, they has deprecated it.
Yes.
Yes, ma'am. Yes, my lord. First of all, if the rate itself is maintainable, because Ronak Agrawal is not the owner, his father is owner. A father is alive. Father is alive. In between father, respondent number 4, civil suit is lying pending, and they are contested. It's the same subject matter.
With regard to the same subject
Same
matter?
subject matter, same land.
Please show me the plaint.
There. And another thing, my lord, one suit was filed by Pulchan Agarwala, father of Ronak Agarwala, that is dismissed. That's
Please show me-
everything is suppressed.
Please show me the plaint. Who are you? You are the adjacent owner.
I'm the owner of the land.
Adjacent owner?
No. I'm myself is the owner of the land. This putted land is owned by me. He has simply a sale deed. And he filed a suit in the 2015 for declaration that he's the owner. That suit is dismissed for non-prosecution. That suit is
Please
dismissed.
give me the plaint.
We have challenged that deed, which is lying in his position, that I'm the owner, that did be declared null and void. That is within being contested by the Pulchan Agarwala, father of Ronak Agarwala. Question is, when his father is alive, he is contesting the suit. How his son can come before this your lordship under writ jurisdiction and suppressing all these facts in the affidavit. Nothing is there. Whether Pulchan Agarwala gave any authority to this Ronak Agarwala to file any suit, file any writ petition, or lodge any complaint to corporation. There's nothing in the writ petition.
Are you making any construction on that plot?
No,
Already
this is
made, my lord.
2015, my lord. In their deed, which they filed, their deed, which they filed along with the suit, along with the writ petition. I'm coming to that.
Yes.
Page number 21.
Yes.
Page number 21. Their deed.
Yes. Have you got instructions?
No, Lordship.
Huh?
No, Lordship. If you Lordship will direct the commissioner to conduct an inquiry and pass a result after giving opportunity of hearing, that will suffice to.
Do you have any idea about the civil suit? Yes, where is the plaint?
I don't have any idea.
But, my lord, I have at present no plaint, but I have the order. The order is annexed with the.
So I can do one thing. I direct the corporation to hear both of you and to pass a result order.
My
on
lord,
that.
one thing is there.
What is the difficulty in that?
No. Question is, if the writ itself is, can this person come and read jurisdiction? When the civil suit is lying pending, being contested. They say that he has been dispossessed. If he is dispossessed, can this writ court can restore the position? There is the suit.
But the question is whether you are carrying on any construction.
No construction.
In accordance with the sanctioned plan.
My lord.
That the municipality can look into.
My lord. If the subject matter is this, then obviously, honorable court can do this.
Yes.
This is 21 page. This is schedule of the land. Schedule of the land.
So do you have a copy of the plaint?
This is with my plaint is not with me. I filed the order, last order of the plaint, or this 144/18. Last order. This is their document.
All right.
My lord.
Lordship.
This is their document.
Affidavit of service filed in court today is taken on record.
My lord, just a minute. It is their deed. Itself
Let the
reflect.
corporation take instructions.
It is reflected that one minute. 190 square foot out of total undivided land measuring this. One tin shed roof structure. This is all construction is being done.
All right.
No new construction.
The learned advocate appealing for the Jalpaiguri Municipal Corporation pressed for an accommodation to revert back with necessary instructions. Monday? List is
My lord, if my lordship pleases to direct them to after conducting an inquiry, my lord.
No, not inquiry at this stage. List this matter on Monday. Yes. Next.
84.
Lordship,
Monday, Shatastra. Income tax.
Lordship, in item number 84, Senior Counsel Mr. Afratosh Majumdar is flying tomorrow to the circuit bench. So,
Not today. Next.
20?
23rd.
Third. Lordship, I fix it on 23rd.
23rd. All right, on the prayer of the learned and poor for the petition, this matter on 23rd.
Lordship, if possible, top of the list, Your Lordship, he has a returning flight.
Above in the High Court of Calcutta. Yes, next.
Great.
Yes, yes. 84, 95. 85.
Lordship, yes, I am.
Yes, disposed of, same as item number 14. Next.
84. Lordship, similar matter. 88.
86. Same order. 87. Same order. 88. Same order. 89. 89. Yes.
Here, group 4, my lord, GST matter. Here, my lord, I am challenging for the tax period 8-19. I am challenging the expertise adjudication order and show cause notice. In the show cause notice, the personal hearing column not applicable and one adjournment not applicable, covered by our division bench order Gautam Bhomik, and also additional notices portal. That additional notices portal also I am carrying the judgment of our coordinate benches, my lord.
Yes, Mr. Vishro.
Yes, Mr.
My lord, my humble submission, my lord, may be remanded to the adjudication stage for filing reply and opportunity of personal hearing. Show cause
Your Lordship,
notice at my lord page.
In personal hearing in all
Yes.
matters are not given by the tribunal. Only in
No,
case
I
of
could not
doubt
follow. Yes.
whether, Your Lordship, the procedure is that personal hearing in all SIR matters are not been given. Only in case of where there is any
This is a GST
doubt
matter.
which the tribunal requires to clarify, then they
No,
call
this
for a
is a
personal
GST
hearing.
matter.
Oh, I'm so
This
sorry.
is a
I'm so
GST
sorry.
matter. This.
Page 73 minutes.
72.
Starting page of show cause notice 64, and my lord, the personal hearing part at 72 not applicable, and 73 reminder, that is also not applicable.
73 is
Reminder.
What is the original one? Is 72.
72
and 73.
23rd bulletin.
and also additional notices tab, my lord.
This is the so called under what? 73.
73, my lord. For the tax period 18-19.
1819.
18-19.
Yes. Then
Then, my lord, order pass 74.
order passed is 74.
Page 74.
Yes.
And also not noted in the order, it is not noted that personal hearing given. And also it is uploaded in the additional notices tab
This
portal.
order was uploaded in the
Additional notices tab portal. And my lord, I have attached here with my lord the screenshot of the portal at page, starting page 95, but operative page is, my lord, 97.
Yes.
Last line, my lord, the additional notices tab has now been merged with notices tab. Accordingly, all the notices and order issued from various modules under henceforth displayed only under this notices and order
So
tab.
when you came to know of this order, when you came to
Yes,
know of
on
this-
18 May 2026, my lord, at para 11 and 12, I have mentioned, my lord.
18th May 2026.
Yeah, and my
So
lord,
by that time the appeal period was over.
what? And page 86, that notice I have received by hand from them. Page 86.
Page 86.
18 May 2026. By hand received this letter, my lord, from them. This is the intimation for demand payment of demand.
Then you came to know.
Then you come to know and file the writ petition, my lord, thereafter. And para 11 and 12 of the writ petition I mentioned. And my lord, the merging of the portal, that is, there is no notification and circular, only got no knowledge. Media news attached, I have attached in page 93.
For what? Media news?
Additional notices tab.
That merging is talking.
Merging, you have annexed that.
Yes, no, in including, my lord, media news annex, because there is no notification circular FAQ. So to support my contention, that I have attached, my lord, page 93. And my lord, may I submit, my lord, coordinate bench order, my lord, recent coordinate bench order passed by Honorable Justice Mr. Mishra also appeared.
Then he is a stop. He cannot say anything. That decision, he cannot say anything.
No, maybe the facts that I stated there as a petition will all be wrong. Who knows?
এটা একটু just দিন। এটা আপনি করেন, এটা আপনি করেছেন। এটা একটা দিন। And my lord, may I submit your lordship order, my lord? Shankar Agarwal.
One order will do.
Yes. This is the latest order. This is latest order, clarifying all this issue.
The order of the adjudication order dated
12th April 2024.
dated 12th of April 2024 passed by the respondent number?
Respondent number, my lord, 4.
Passed by the respondent number 4.
Under section 73.
Under section 73 of the WBGST.
WBGST and CGST oblique.
Of the West Bengal Goods and Service Tax Act 2017 is under challenge in this writ petition. Full stop. The learned advocate appearing for the petitioner draws the attention of the court to the show cause notice.
Page 64, my lord, dated 14th December 2023.
To the show cause notice dated
14 December 2023.
Page 64. Dated
page 64.
14th December 2023. And submits that a time was fixed for no, show cause reply time has been fixed. No.
Time fixed, my lord. Page 72.
Page 72.
72. Middle portion, my lord. 15 January 2024. Time fixed.
That though a time was fixed for submission of reply to the show cause, but the date, time, and venue of personal hearing was not mentioned therein. First, he further submits that a reminder letter
dated
to the show cause notice was issued on 2nd of March 2024, fixing 11th of March 2024 for submission of reply to the show cause notice. But even in the said notice, the date, time, and venue of personal hearing was not indicated. First up, the learned advocate appearing for the petitioner submits that the order under section 73 within bracket 9 was passed on
12th April 2024.
On 12th of April 2024 without affording any opportunity of hearing to the petitioner. First up, he further submits that the all these things were in the additional or only the
No,
order.
no, no, all this additional. That is
The show cause notice reminder.
All this.
The learned advocate appearing for the petitioner further submits that the show cause, that the initial show cause notice, comma, the reminder letter, as well as the order under section 73 within bracket 9 of the WBGST Act 2017 were uploaded in the additional notices and orders tab instead of the normal tab. First up, he thus submits that the petitioner was not aware of the dates fixed for giving reply to the show cause notice. First up, he further submits that upon being served with an intimation for payment of the liability against demand created under Section 73 of the WBGST Act 2017 dated 18th of May 2026, the petitioner for the first time came to know of the adjudication order passed under Section 73 within bracket 9 of the 2017 Act. First up, he submits that he submits that in the meantime, the period for preferring an appeal also stood expired. First up, the learned advocate submits that since the adjudication order under Section 73 within bracket 9 was passed without affording any opportunity of hearing, the principles of natural justice has been grossly violated in the case on hand, for which the petitioner has approached this court under Article 226 of the Constitution of India. First up, paragraph. Heard Mr. Lanet, Assistant Additional Advocate General on such submission. First up, he submits that the adjudication.
The Act envisages that under Section 161, whatever is uploaded in the server is deemed to be a notice, and therefore sufficient compliance has been there.
Submits that
169. 169.
Submits that it is not in dispute that it is not. Submits that the show cause notice, the reminder letter, as well as the adjudication order was uploaded in the server, and therefore there was sufficient compliance.
Threshold compliance of 169.
There was sufficient compliance of the provisions, and the petitioner cannot feign ignorance of the show cause notice and the adjudication order. First a paragraph. আচ্ছা ওইখানে না পিটিশনারের ওইখানে পরে একটা লাইন লিখে দিন the learned advocate appearing for the petitioner places reliance upon an order passed by places reliance upon an order dated 7th of July 2026 passed by a coordinate bench in WPA 2425 of 2025 in the case of Ashok Parak, Mrs. Ganapati Exports versus State of West Bengal and others, in support of his contention that the adjudication order is liable to be set aside on the ground of violation of the principles of natural justice. First a paragraph. Heard the learned advocates for the parties and peruse the materials less. A show cause notice dated 14/12/2023 was issued in form GST DRC 01 under Section 73 of the WBGST Act on the alleged on the ground that certain discrepancies were found in the returns for the tax period April 2018 - March 2019. First up, though the show cause notice specifically states that the reply is to be submitted on 15th of January 2024. But against the column under date of personal hearing, semicolon, time of personal hearing, and venue where personal hearing will be held, it has been stated as NA, capital invert comma, full stop. The reminder letter dated 2nd of March 2024 also is silent about the date, time, and venue of personal hearing. Full stop. Paragraph. Section 73 within bracket 9 of the WBGST Act 2017 states that the proper officer shall, after considering the representation, if any, made by the person chargeable with tax, determine the amount of tax, interest and penalty due from such person and issue an order. Full stop. On a bare reading of the said provision, this court finds that the amount of tax, interest and penalty due from a person shall be determined by issuing an order only after considering the representation, if any, made by the person chargeable with tax. Full stop. The petitioner alleges that the show cause notice as well as the reminder letter was uploaded in the additional notices and orders tab and not in the normal tab. The issue whether uploading of notices and orders in the additional tab and would and can be said to be an effective communication, the issue now fell for consideration before the Honorable Division Bench in the case of, where is the Division Bench judgment?
Yes, madam.
Honorable Division Bench in the case of such and such versus such and such, reported at such and such. Full stop. The Honorable Division Bench, which paragraph?
Paragraph, my lord, my I'm searching, my lord. I have marked my copy. Gautam Bhomi. I'm praying a moment.
The Honorable Division Bench specifically observed that notices and orders uploaded in the additional tab cannot be said to be proper communication of notice to the person concerned. Full stop, paragraph. That apart, the show cause notice, that apart, in the show cause notice and the reminder letter, the date, time, and venue of personal hearing was not indicated. Full stop. Thus, full stop. The adjudication order was passed without affording any opportunity of hearing to the petitioner. Full stop. Thus, the adjudication order has been passed without complying with the provisions laid down under section 73 within bracket 9 of the WBGST Act 2017. Full stop. For such reason, this court is inclined to interfere with the ex parte adjudication order. Full stop. Accordingly, the order of adjudication dated,
My lord, 14 April 2024.
14th April 2024, passed by the
12th of April, sorry.
12th of April 2024, passed by the
Respondent number 4.
Assistant Commissioner.
passed by the fourth respondent, is set aside. Full stop. The petitioner is granted liberty to file a reply to the show cause notice within 14 working days from the receipt of the server copy of this order. Full stop. The fourth respondent shall fix a date of hearing and shall dispose of the and shall decide the issue raised in the show cause notice by passing a written order as expeditiously as possible. Full stop. It is, however, made clear that the order of adjudication has been interfered with only on the ground that the same was passed in violation of the principles of natural justice. Full stop. All points are kept open to be decided by the adjudicating authority in accordance with law. Full stop. একটা জায়গা একটু করে দিন, ওই যেখানে অ্যাডিশনাল ট্যাবস বললাম না, it is not in dispute that at the relevant point of time, the show cause notice, the reminder letter, and the adjudication order was uploaded in the additional tab and not in the normal tab. Full stop. Thus, there was no effective communication of the show cause notice, the reminder letter, and the order of adjudication. To stop. For such reason, this court is inclined to entertain this writ petition and decide the same on merits.
Additional notices, 1 plus additional notices. Additional notices.
Additional notice. Yes, next.
Affidavit of service given.
Taken on record.
Next, same petitioner, 1920, but here personal hearing given. Here also same all additional notices tab, but in the notice personal hearing fixed prior to the date of reply. And in one first adjournment, personal hearing mentioned in the second adjournment, again prior to date of reply. But the additional notices tab, I missed, an ex parte order passed, and thereafter, my lord, what happened? The tax consultant filed the appeal against the pre-show cause notice. So thereafter, appellate
This has to
authority
Come
rejected.
tomorrow, come tomorrow. There
This
are
has to be adjudicated on affidavit.
Yes, call the next
No,
matter.
My lord, this matter also, my lord, suppose should go to the adjudication stage because appeal. Because I'm telling, my lord.
No,
because-
opportunity was given.
No. Opportunity not given. That is
All right. Tomorrow.
tomorrow I may be appear virtually, my lord.
All right.
I'm good.
Yes.
My lord, 118, my lord, registration cancellation matter, my lord. May I have one?
Yes, call the next matter. We had a fixed করেছিল.
Oh,
Call the fixed matter. Yes.
Item number 79.
But I am for the petition.
I'm sorry, my lord, I was.
Yes. Yes.
My lord, petitioner prays for my lord approval of his appointment as a Gram Panchayat Kormi. My lord, on the earlier occasion, your petitioner came before this honorable court. My lord, this honorable court passed an order which is at page 27.
Yes, what do you say? After this,
After this, my lord, the representation is page 47. If this is considered, my lord, in light of the recent order,
Yes.
possibly, my lord, this will be, because this was,
Well, that- that-
placed, my lord, before for necessary approval at page 44A, my lord, I am reading.
as at page
44A,
44A,
there's a type copy, my lord. The second last paragraph, which starts from hence. Hence, the
Yes.
undersigned not being the competent authority as per para such and such, dated such and such, read with memo number such and such, dated such and such of Special Secretary Department of PNRD to approve benefit to the petitioner, sending all the relevant documents along with the observation made above for according necessary approval to the additional Chief Secretary Department of PNRD, Government of West Bengal. This is
Yes.
possibly lying at the end of the additional Chief Secretary Department of PNRD.
yes.
If this is considered, my lord, there's a representation pending.
What representation pending? This matter has been forwarded to him.
Yes.
So what is the decision? How
Decision-
long, how many directions will be passed?
My lord, with regard to decision, my lord, I don't have instructions because possibly, my lord, no decision has been taken. Possibly, my lord,
Possibly.
no decision has been taken as of
So
now.
please take a decision. So I'm keeping it at the next week, Monday.
Monday, my lord.
The service man.
The petitioner has prayed for a direction upon the
My lord, the additional Chief Secretary, my lord, is possibly not a party respondent here, my lord.
My lord, principal secretary is
has-
there.
But it is lying with the additional Chief
please
Secretary.
implete the additional chief secretary. I am giving you leave. On the pair of the learned advocate for the petition, leave is granted to the learned advocate on record to add additional chief secretary, Department of Panchayat and Rural Development, Government of West Bengal as a party respondent. Please do that. Party respondent in this petition.
Lord, my-
Since the state is
My lord,
Yes.
my junior may be, my lord, correct.
yes, since the state is represented by the learned additional government pleader, there is no necessity to serve a copy of the writ petition upon the added respondent. However, the learned advocate on record of the petitioner shall be obliged to forward an amended cost title of the writ petition upon the learned advocate appearing for the state. Paragraph, the petitioner claims for grant of approval in his favor for the post of Gram Panchayat Kurmi within bracket Group D at Panishala Gram Panchayat. First of the learned advocate appearing for the petitioner submits that pursuant to an order passed by the coordinate bench, the District Panchayat and Rural Development Officer Kuch Bihar passed an order dated 28/12/2020. He submits that in spite of a specific direction passed by the coordinate bench, the approval has not yet been accorded in favor of the petitioner. The learned additional government pleader submits that the matter is now pending consideration for grant of approval before the Additional Chief Secretary, Department of Panchayat and Rural Development, Government of West Bengal. First up, he seeks an accommodation to revert back with necessary instructions. First up, let a report be filed by the additional report be filed, not in the form of an affidavit.
Just a report, my lord, yes.
Report be filed by the additional, by the added respondent on or before the next date of hearing. List this matter on July 28, 2026. Yes, next matter. 91. Yes, who is appearing?
আজকে কি ইয়ে জয়েন করেছিল তো আমাদের আছে